Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican po, he's verbis Latino. Oh, for crumb's sake.
Literally not true.
Is that correct?
I didn't ask you to interrupt me.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm blurry. Now I'm not. Welcome. Just trying to do some last minute updates as you saw popping up on the screen there. Let's see if this is working. Maybe. Okay, we're on beta 2. The seats should be working again, and there's a chance that it will show up gifted, that I can put like gifted memberships up on the screen as well. Like that I haven't been able to do previously. We'll see if that works, but all right. Welcome, one and all. Camilla Juliana, congratulations. You were first in chat. This is a good thing for us, probably a bad thing for you. We're going to send it to internet ownership. Your promptness is being punished by extra duties on your shoulders today. You have to, thank you for the reminder about the glasses. I'll need those. Hang on. This is my coworker calling right now. Hang on one second. For the gig. So hold, please.
In front of the Walmart.
Hush! I'm trying to have court. Don't raise your voices.
There's nothing in the order that restrains you from talking to cats.
You don't put a diplomatic plate on a hoopty.
I was kicked back, taking it easy.
All right. We'll turn down the music. Sorry. Thank you, Bradley, for the call right then. The gig I've got this weekend suddenly doubled in size, meaning that's now 2 days. 2 days of heavy work instead of just 1 day plus a little bit of light work. They just asked for everything that I wasn't planning on setting up and running on Saturday at a different location, and cha-ching. I guess I should just say that. That's good. But it's logistically, it's crazy. They're like, okay, now we want something we've never done before. Can you make this happen? Plus, there are 5 different presenters.
In front of the Walmart.
Can you go? Yeah, it's like No problem. I said I got you. I've got a cable for that. All right, welcome. We're going to get started here in just a minute, so we need to actually hurry. Believe it or not, we're falling a little bit behind. It is music still going on. That's crazy. It is good to be here. It is good to be here back in a big trial, which we have getting ready right now. So. You guys have waited for this for a while. We sat through a pretty boring trial yesterday. At least some of us. Some 330 of us did. The rest of us didn't. I won't say who did and who didn't, but anyway. Let's see. What else did we wait for? We waited for...
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I need water. One and a half. I need water. It's because I coughed at the end. I choked is what happened. I choked. It's hump day. You've been warmed. Thanks for the warning. Oh. Solid 9 last week was best. That was good. That was good. It is. We are on Wednesday already. For those of you who have lost count or are counting, we are halfway through the work week. Unless you have some weird schedule, which we're all going to be jealous of, because that means you get a holiday before us, or at least a weekend before us. We are halfway there, so that's great news. It's all downhill from here. Oh, I need water. I think that... Oh, maybe they thought I was joking when I said that. Can I get 3 more, bud? My son likes to speak Spanish to me, even though I don't understand what he says. But I understand. Ooh, oh, that's good. Wow. That just came out of nowhere. Just caught us by surprise. A red pen says, Buffer, we have the one and only birthday today. It's Mari, HK. Is it Mari or Marie? Or Mary? I guess there are other options. Additional water being delivered. Thank you, bud. Have a great day at school. He also likes to say danke to people, which is German for thank you or thanks. Let's see. Mari. I'm going to call it Mari HK. Is that all right? Pronounced Mary. So close. First try. We'll do it, Mary. Mary HK. All right, everyone stand up, take the breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor. Warm up with me if you will. La 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 la. We're going to add Olga in here as well. Happy birthday to you. Happy birthday to you. Happy birthday to Mari and Olga Elijah. Happy birthday to you. Oh, and Allie B. We've got Allie B today as well. New verse. Water. Ooh. Happy birthday to you. Happy birthday to you. Happy birthday, dear Allie B. Happy birthday to you. Red Pen just shouts out now. This is what the form is for. You can actually, there is no, we're not pointing fingers, Allie B. We're not pointing fingers, Olga. We love y'all. You can get your name on the form in advance. That is what it's for. Literally. If your birthday is in 350 days, add it to the form today. Because then when it comes around, we'll already have you. And we won't miss you. And it will take the stress out of the mods' lives. So, just a friendly, loving reminder. Allie B's like, I know, I forgot. But now, thanks to you, Allie B, lots of people are remembering. We appreciate you. If it weren't for you doing this today, we wouldn't have this opportunity to teach others. Thank you, Allie B. Happy birthday. Happy birthday. I hope you have a great one. I realize there are a million places you could be and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. And hopefully we can turn some of that joy back to you, make your day a little more special, and begin by helping yourself to free pancakes at Denny's, IHOP. Not that place. Tammy Dunlap's, McDonald's, Bob Evans, Andy's Grill, and Cracker Barrel. We struck Waffle House from the list because yesterday Legally Blonde went there, asked for her free birthday breakfast, sorry, and didn't get it. Drum solo, here we go, ready? Beautiful. And what perfect timing we have. What perfect timing, because court is about to begin. It's about to begin. We've just got a couple minutes. Happy birthday, everyone. Good hump day yell, but I forgot. But I thought you were choking. I was. K-Cat. That was not. That's not a performance. You're seeing what could possibly be the last few seconds of my existence, all for you. Katrina Buddy said I just added my birthday for July next year. This is how it's done, Katrina. See, this is what we're talking about. For some reason, I'm on top chat. Let me switch that out a little bit and also recognize a couple people who came in early. Kelly H with a hump day. Super chat. Kelly, thanks for kicking things off that way. That's awesome. And your generous support of the channel is much appreciated. Makes it all possible. Tash, welcome to the gallery. Thank you very much. And also, Tash, 23 months, almost 2 years with my favorite addicts. You get a new courthouse next month, which you know. You can't wait. Thank you, RA, mods, and chat for all the love anyway. Always. Brenda Meyer, 24 months. Tash. OG. Brenda Meyer, also an OG. Good morning, chat family. No other place I would want to be. Thank you. Grace Sanchez, upgraded membership to the jury. Grace, with 27 months, with 26 months under your belt, now 27, I guess you could say, you finally decided those hard seats are just not for you. You've reached the point in your life where comfort is king, or queen in your case. And no more will you be sitting on a hard bench. But no, we have reserved for you a padded chair on the jury. And yes, it does slightly recline. Happy not birthday. Far. It's not like you can sleep in. It's not a lazy boy. Okay, you're not the attorney level. That's different. But a padded chair with slight recline on the jury. Help yourself to that, Grace. Thank you for your support. Another OG. 27 plus months and now on the jury. That is awesome. Wonderful. Good to have you here. Thank you. Thank you all for your support. You're hyper today, and I'm here for it. Denisha, I'm so excited to have a case again. Yesterday was I can't begin to tell you how bad yesterday was. I can. Over half of you weren't here. So this is new to half of you. We went to court, Thurston, Washington. In the morning, we were with them for about half an hour. And then we sat with them basically for 8 hours. Okay, straight. 8.5 hours. Got the verdict music. Twice. And then when the verdict came in, there was no mic and we didn't get to hear it. It was probably the worst, I hate to use the word climax, you could possibly anticipate in court. It was terrible. Amber says, remember, for almost every form we have, you should have the option to edit your private response if you were logged into your Google account when you filled it out. Your info is not shared. No, we keep it to ourselves. I don't even know how to get to it. It's not even shared with me. I'm just going to say, yes, it is. There's a way, but I don't know how. Yes, we had the mute button for their new, and this was not my mute. This is not like, hey, sorry, my bad, guys. I should have pushed the button. This was Thurston County doing Thurston County things. And this is after we sat through probably close to 45 minutes of dash cam, body cam, security cam video where we both could not hear or see. It was bad. It was bad. It was a rough trial. Thurston, you're going to have to redeem yourself. Find Farag, and then we'll talk. All right. And Josh says, yep, we're not going back to Thurston ever again. Sorry, Thurston. I love that court. I really do. But, man, they've got to do better. Got to do better. What was the verdict? Guilty on both counts. And he got the minimum legally allowable sentence for both, which was 1 day credit time served and the other remaining day that he has to serve in home confinement and then probation. Let's see. I'm well aware your Google Drive, Discord, and Facebook illiterate. That's why you have me. Yes. I'm Zoom illiterate too. Bradley, who you just saw here, was just on the phone, letting me know that he's set up the Zoom for this weekend thing we're doing. It's a webinar. It's not a Zoom room. Webinars are a little different. It's basically like the YouTube version of Zoom, where it looks like Zoom, but you don't get everyone's boxes. I can just push out one signal to everybody and control everyone, make sure that nobody can talk and nobody can do anything. Olga Elijah gifted 5 memberships. Happy birthday on Sunday. I'm sorry we missed you. Thank you very much for your generosity. Glad we could include you in the song today. John coming in with a hot take says Thurston sucks in every way. Please stop going. John, thank you for sharing that. Today I agree with you. Although tomorrow they might have a funny court, and I'm like, well, maybe just this one. All right. Let's see. A trial of my own to attend on Halloween. I was subpoenaed yesterday as a witness against a woman who concealed my stolen Vespa for 3 years and destroyed it. Reverend Beasy. That's terrible. Who conceals a Vespa? I hope insurance made you right. If somebody were to steal my e-bike, I would feel frustrated at them for a long time. Jersey Prods, closer and closer to a year of official membership, although I've been here since Maya. That makes you an OG. Thanks for all you do, and thanks for the official 10 months of support. Bailiff is getting ready to let people in the courtroom, so soon we'll get some audio, I'm sure. Let's see. Congratulations, new members. Welcome one and all. It's good to have you here. We are back. We're back. We did hit 67,000 subscribers yesterday, and we kept it. Many times we hit a benchmark and then we fall back under a little bit, but we're now at 67,000, or 67,007, which is like the James Bond reference there. So you've got to call that out. I think I missed Melanie renewing her membership. Oh no, Melanie, let me look. I think I did miss you. Where are you at? Melanie, 18 months. Happy hump day. Love chat community. I've been here since Brooks, and this makes you an OG. And his box fort. Thanks, R.A. Your great best sound on the interwebs. I do try. We'll see if we can continue that up today. Oops. And then I broke everything. There we go. We're back. Here's another OG. Marilyn Skoll. Love you and all who was here. 31 months as an attorney. This is the padded leather reclining headrest and footrest chair. Marilyn, thank you very much for your support. That is huge. Honestly, from the bottom of my heart, from my family to yours, thank you. Love your support. Love that you've been here for 31 months. OG! That is awesome. That is just really cool. All right, waiting for audio. Don't have it yet. Obviously, the defendant is here, Jose Soto-Escalera. He has been, I won't say defendant anymore. The convict. He has been convicted. The jury has found him guilty.
We were going to be instructing the jury. The jury clerk apparently told our 4 alternates who reported downstairs that they were not needed and sent them home. They're being retrieved. One of them, I'm told, is 30 minutes out, but that was 5 minutes ago. Lacey Clark. But
why are you naming them?
To work on the courtroom, but that'll be working when we need it. Mr. Byrne wanted to address some scheduling issues, though, which we have an opportunity to do that now since we're not ready with the jury.
Sherry and Max, 11 months. Thank you very much. Sarah Lawrence. His mic's off.
Roughly 2/3 or thereabout of our anticipated penalty phase witnesses. This is due to the public nature of the trial and the attendant social media yammering about it. I have many witnesses who have been contacting me since the verdict saying I can't do it. People are saying things already. I'm going to get mean comments. I'm going to get trouble at work. People are going to look at me crosswise. It's not the type of situation that could be remedied by serving them with subpoenas and bringing them in here in this circumstance where I'm begging for a man's life. I can't have witnesses shooting daggers at me 90% of the time and spending the other 10% of the time glaring at Jose. if they don't want to be here, I cannot use them, is the practical nature of it.
It's true.
So my plans have been quite upset in the past few days, but I'm going to have to work with what I have. What I have at this point is a prison expert who is available to testify remotely this afternoon beginning at 1 o'clock. He's available at any time from 1 to 5. I have a lady who knows Mr. Soto-Escalera in previous years. She, I think, can come and testify in person this afternoon. That is all I have ready for this afternoon. I do have, I believe, 4 of Mr. Soto-Escalera's family members flying down from Connecticut. I thought that they were getting on a very early flight this morning. It turns out they're not leaving from LaGuardia until 3 o'clock this afternoon.
What?
I will not have a chance to interview them and find out exactly what they are going to say and whether it will be contradictory to other people in the family as to what they have to say. There is some difference in perception between older members of the family and youngers. And so I'm not sure who of the 4, maybe all, maybe 1, maybe 2, that I will end up using. Mr. Richardson, of course, has expressed an interest in deposing these witnesses beforehand. So I'm not sure what exactly I'm suggesting there, but it's going to be a late night for me and Ms. Minton. These witnesses would presumably be available to testify tomorrow. And that's about as much as I can update the court right now.
And Judge, can we just approach for a bench conference, because I don't want the rest of this that I need to lay on the record aired on Court TV.
Sure.
Thank you.
Wow. Guess who's not granting an interview post-conviction? Her. Wow. Teresa K. So it's our fault people don't want to speak for him? There's that. Lindsay Ross, member for 8 months. Good morning. Always forget to fill in my monthly free membership. Been here since Maya. That makes you an OG. Thanks, Rob, for the recommendation. Rob is great. I am so grateful for his recommendation. That was a huge boost to our channel. So thank you all who came from Law and Lumber. Sarah Lawrence, I didn't get to read this out. I'm not in chat often, but I love this channel and everyone in chat. 7 months. Thank you, Sarah. That yellow courthouse looks great on you. Little bit of a cluster. I'm not sure. I can't use any other words other than cluster this morning on the defense side. Considering what we went through last week with the defense specifically, we had an issue where they're like, we have all these people, language barrier, technological barriers, just financial barriers. We need to get all these people down here. We've got to fly them down, Judge. We've got to rent a 737. We can't. Buses aren't an option. We can't do a convoy of buses. We're gonna need the big plane, and we'll got to fly people down. We'll probably have to charter the thing. Just make sure we've got the whole thing reserved for us. We've got so many people who want to speak to about Jose and what a great guy he is. There's no other way to do it. And the judge is like, have you heard of Zoom? And he's like, oh, yeah, there's that. Well, okay, we'll do that. Then, along comes this morning. And the 737 of people have now vanished into thin air. Four people want to speak for him. And they didn't get tickets till 3 o'clock in the afternoon. Like they won't. It'll take it's a 2-hour flight, right? It's probably a 2-hour flight. I'm guessing 2, maybe 3. I don't know the exact math. Well, Florida might be 4. Might be 4 hours max. They're not going to be here till this evening. They're missing today. Today is the day. Why did you not get them tickets sooner? Why do you not just say, hey, never mind. Zoom it is. Cancel your tickets. They just want to go to Florida. We heard there was a beach. What time is court? I think I'll be back from the beach by then. I'll see if I can make it to court. Apparently we had plenty of money, just buttloads of money to spend on flying a 737 full of people down here to speak for Jose last week. But now I guess the only flight that was available is the 3 p.m. cheapy, which really isn't the cheap flight. Can the judge just say, forget it and do it on Zoom? Yes. We're doing it this morning. You can fly down to Florida if you want, but you'll be done before it's time to go to the airport. Nicole's celebrating a milestone. I will jump back up here just 1 second. Nicole Watson, member for 12 months. Hit the year mark. Love being part of this community. It's awesome. Nicole, thank you. I love that you got a cat in your profile picture, which looks completely relaxed and ready to claw something if you wiggle your fingers too close to it. Congratulations, by the way. I have to do a shout out to our good friend Ian Runkle, who is now a cat owner. Doesn't know it yet, but the cat has been distributed to him. If you watch on Twitter, he's now a cat owner. That's awesome. He didn't know he was a cat person. He thought he was just a dog person, but cat it is. Kathy Mazak, loving the pink. Hit the like, everyone. Kathy, OG, 25 months. Awesome, Kathy. Awesome. Thank you. I fly from Dallas to New York. It's a little over 3 hours. Okay, so either way, they're going to miss it, right? Flight's 2.5. I'm thinking 3 o'clock, 2.5, half an hour to get out of the airport. That puts them at 3. If traffic's bad, half an hour. I don't know how far is the airport from the courthouse. It's basically end of day. They pretty much missed it. I got the hiccups. Sorry. Chris Wallace just gifted a membership. Thank you for your generosity, Chris. That's awesome. Apparently, poor planning runs in this family. It's not fair for the victim's mother to be there waiting. Unholy Saint, member for 28 months. OG. Watching from Arizona. Glad to be here. We are glad you're here as well. Look at that pup. That's a great pick. Unholy Saint, that looks great. Thank you. Long time supporter, OG. The jury wants this done, period. Yeah. How do you tell the jury, sorry? After first of all, four alternates got sent home by the clerk erroneously. Clerks, quit talking to the jury. The judge will talk to the jury. The clerk, all you should do is nod and point. And when they're coming in, you point at the jury, a deliberation room or the holding room, and you point to the courthouse when they're going. You don't talk to the jury. Have we not learned this before? Do we learn nothing from Murdaugh and Thurston? Lost her added a whole day yesterday in Thurston County. Yeah. Traffic in most places in Florida is nuts. I'd agree, but we've got some things going for you, right? You're in the middle of the week. Okay, so it's not really people going for a weekend trip somewhere. It's the school year has started, so kids are in school. It looks like they're about done with their.
It was discussed here at the bench. One of the lawyers has advised me they think that one of the jurors' physical appearance was broadcast in violation of the court rule. Don't know whether that's true or not, but I do want to re-advise the media not to do that at any point, not to show the faces of the jurors. All right, so that's understood in that regard? Okay. And any word on our extra 4 alternates? We're still waiting on one. Okay. Well, let's go off the record. Let's give the Zoom a try. Globally, as far as that's concerned. So my plan would be, based on what y'all told me, we would do whatever we can this morning with the states. The state has victim impact. Does the state have any other evidence other than victim impact?
They've already given it.
That's all. Okay, so we would do the victim impact. Then what would be the earliest that your prison expert or the other witness would be available?
1 p.m., Judge.
1 p.m., so that we would break till 1 p.m., do that. We would reconvene tomorrow, hoping to get those witnesses on that flew down tomorrow morning. And if you needed some extra time to talk to them briefly, we might be waiting for jurors as we were doing right now. We would do that, and then perhaps we would have the closings either later in the morning or early afternoon, and we would just go that. So it's not a major adjustment to our schedule, right? Does that sound?
Did you say closings tomorrow afternoon?
Tomorrow afternoon.
Yes, that's fine.
Tomorrow afternoon.
The only,
Doesn't that accommodate everything for the defense? I believe it does, because you have their people flying in today, and then you'd have them tomorrow, and we were able to do the closings tomorrow afternoon.
Oh, I could probably survive it, Judge, yes.
Yeah, why not?
So to be clear, tomorrow morning I would have an opportunity to at least speak to these folks.
And if they're here.
They present their evidence, and then we just close in the afternoon. Yeah, that's fine with the state.
Yeah, so that would be the plan.
Yeah.
To accommodate the communication snafu regarding the witnesses flying down. That's what caused us the difficulty logistically.
He said snafu, I say cluster. Either way, I think we're speaking the same language.
Let's get the Zoom straightened out, though. We don't have all of our 16 jurors yet. All right. I'm going to go off the record momentarily.
Yeah, we'll get a quick break. So it is going to be Zoom, but 4 people still flying down from the great northern country of Ohio, or state of Ohio. Is it Ohio they're coming from? I need a drink after that. Water, just water. All right. This Little Piggy Productions, I love the name, by the way. The defendant is allowed in street clothes. Because the jury is still deliberating, that they don't want to have a situation where the defense can say, because my client was forced to walk in the courtroom or stand in the courtroom in front of the jury in shackles and handcuffs and orange jumpsuit or stripes or whatever, that image made him look like a bad man, and so they voted for death penalty. You don't want that situation, so they allow him to still wear his regular clothes. If this was just a judge, if this was a bench sentencing, not a jury sentencing, he'd be in a jumpsuit, because the judge is presumed to be fair. First of all, there's that presumption that he can look at as someone who looks at evidence and says that does come in, that doesn't come in, that is considered, that's not considered. He just looks at the clothes and says that's not considered, right? I don't look at you and say, oh yeah, he sure looks guilty. Boom, hit him with a max. So when the jury's still deliberating or has options to choose, he'll still be in regular clothes. Well, he is a bad man. They found him. Yeah, the same jury did convict him of 2 counts of capital murder. So, court, that's the best way to drink water all at once. Let's see. Irvin Beasy says 7. I always appreciate hearing your point of view. You make me think a lot. Love you for it. Both of you. Thank you very much. Appreciate it. Let's see. He'll get death penalty because of the unborn baby and the callous nature of it. I don't think it's a given, John. Mostly because the public sentiment towards death penalty is waning. It's diminishing. The support for the death penalty is diminishing, and there are some people who would be convicted in a heartbeat. But I don't think anyone should get the death penalty. There's the thought process is, how does killing another person make it right? Right? That's the logic behind it. And there might be some religious viewpoints and stuff that come into play there. But there are a lot of people with that opinion. And so Florida has recognized that. And in an effort to still get more death penalty convictions and sentences, they changed their rules. They changed the law to say, okay, 12 people have to convict to make you guilty. But once you've had the 12 people convict, then we enter the death penalty sentencing phase, and only 8 have to agree to get the death penalty. So you can have 4 people who would say, yes, he's guilty 100%, but I don't think you should kill him.
Some, if not most, of our Connecticut people will be speaking in Spanish. We will need an interpreter for that.
Okay, court-certified interpreter.
And Judge, will need them here at 8:30 because the state intends to interview our witnesses at 8:30 in the morning tomorrow morning, so that the interpreter can interpret for the state.
Thank you. Let me show who's in charge of the interpreters now. Deputy Court Administrator know.
The judge is not holding the line, really letting the defense push and get pretty much whatever they want. If I were the judge, I would be super frustrated, as we've got, like I said, Ohio, it was Connecticut, witnesses from Connecticut who were supposed to be connecting over Zoom. That was going to be the way that we saw the witnesses, and instead they're flying down when the judge said, we're doing Zoom. That was the plan, and now he calls it a communication snafu. Snafu being an acronym. Oh, there's a phone call. Judge.
It looks like you're getting in now. Yep.
Snafu is an acronym.
So what I'm going to do...
Wrong answers
Tim,
only.
I'm going to leave it on, but there'll be no audio for them, but I'll just... actually, now that we're good, before we break, we'll restart it because it times out. So I'll just shut it off. But we've got the Zoom working now. Okay.
He's using the free version of Zoom. He's using the court's just using the free version that times out after a few minutes. What, 40 minutes, I think. It's like you've used all your free Zoom credit. You think they would spend the $12 a month or whatever it takes to upgrade the Zoom to the pro version, which lets you go for hours and hours and hours. Anyway, so we've got the right answer, but wrong answer is only in chat. What does snafu stand for? Wrong answers only. Okay, so we know the word. We're not trying to put in chat. Snacks, nuts, and fruit unlimited. I like that one. Let's see. Any other options? Save money on Zoom, spend on plane tickets. That's pretty much where we're at. Since nice apples feed needy. Yeah. You need well, we're close. We need a U on the end. Maybe the unneedy. Snafu's a prison treat. It's like tofu, only different. See no unusual fierce unicorns. That works. Sunday noon at Fordham University. It's a schedule thing. There you go.
We'll start.
Oh, Dan.
Jury coming in. We're starting. Then we're going to take a break till 1, which means another day of court hopping, waiting for these guys to get their act together. Sneak no alligators from underwater. September needs a free upgrade. Super neat alligator feet ugly. I thought it was short for Snafadoodle, the guy on Sesame Street. Snuffleupagus or something? Wasn't that his name? Sam, you win. Socks are never found united. That's a good one. Yeah. K-Knight says, I had to Google snafu. Well, now you know. Now you know. Let's see. We've got sending new amazing filtering underwear. Ooh, upgrade. Nice. Snafu is tofu's cousin. I think it's quite telling and appropriate that the judge used that term, even though it's probably not an appropriate term for court. This proceeding particularly has been a mess, especially at the end with the defense. Just like failing to recognize how the system works and expecting things that aren't normal and ignoring things that are normal. You got some good snafu acronyms picked out here. Not appropriate, but very accurate. Yep. The colloquial, there's a big word for the morning, Libby. The colloquial, it almost got away from me. Colloquial meaning of snafu has evolved past the acronym. So reading it out, if we were to actually read out what it means, completely not appropriate for court. But basically, the colloquial meaning is appropriate because we've just We're okay with that. We've toned it down. Sam needs a freaking umbrella. Ricky, that's a good one. Simply not a fun undertaking. That's also appropriate. Yeah.
All parties present. I think I need to tell the jurors when they're not ready to come in yet, but when they do come in addition to re-admonishing them about the media coverage and not to talk to anyone, I should tell them there are timeline. What I think is, it's going to be a little quick this morning. We're going to have some witnesses this afternoon, have witnesses tomorrow morning, then the case will be argued to them tomorrow afternoon. Otherwise, they're going to come in here for all of about 15, 20 minutes, and I'm going to release them to 1 o'clock, and they're going to be wondering what the heck is going on and maybe start getting concerned about their own time. So if I do that, it's kind of preparing them for what's going to happen. Is that all? What I'll say is, I'm thinking of saying, because as they'll see, there's a lot of logistics involved with the nature of this proceeding. It takes some maneuvering and adjusting, and that's what's caused the situation. They shouldn't be concerned about that. But once they know, we'll have the case submitted to them tomorrow afternoon. They should be fine. All right, we're still waiting for that other juror to come up, right?
Yeah.
Okay, go off the record.
Unless
She's there? Okay. Oh, okay. All right, so it looks like you've got a few minutes to prepare your video, audio, which you're preparing.
Well, we're back off the record, waiting for the juror who was furthest from the courthouse. He made it furthest home. What's funny is they're alternates. I guess the alternates do have to sit in for the testimony for 2 days. So the alternates did not deliberate. Now they're going to be put back with the jury again for this portion of the trial. And then deliberate, and then not deliberate again. Oh man, Amanda. S.M. Casey, member for 28 months of the jury, OG. S.M. Casey, why is he not in jail attire since he's been convicted? Great question. Because the jury is still deliberating his fate. The jury is not treated the same way the judge is. The judge can look at something and say, I don't consider that because that's not allowed in. The jury, basically everything they're shown, they're sort of allowed to consider unless they're told, wait, sorry, that was an accident. You weren't supposed to see that. One of the things that they don't want to cloud the jury's mind or influence their decision is how the defendant looks in jail clothes. Because if it's like, yeah, that's pretty much where he belongs. He looks like a bad mojo guy. That might influence their decision and say, yeah, death penalty because of that. And they don't want that for appeal reasons. So I hear you, Vicky. I hear you. They convicted him, so why should it matter? It's still an appellate issue. The judge has allowed too much in this case. Yes, he's been pushed all around the courtroom by the defense. Have we seen other people convicted forced to wear orange for sentencing? Yes, Brian Koberger was one. But there's no jury there. I believe it's only when the jury is weighing in on the sentencing that we'll see them in street clothes. Of course, every state does it differently. So, Bridget says, I don't think you get the death penalty, but I could be wrong. I think you will. I think you will. Robert, you're right. You're right. The judge being a pushover and allowing the defense to get what they want does solve problems down the road, or potential problems down the road, where he does sort of bend over backwards to allow the defense the little things they're asking for. The
All right, let's bring in the jury. We'll get started.
Ooh, the recording light came on. That was cool.
All right, the jury is present. Good morning once again, ladies and gentlemen of the jury. And before we get started, at this juncture in the trial, I know that I have drilled into your heads, hopefully successfully, to be sure to avoid any media coverage of the case. Also, not to talk to anyone about the case, including your fellow jurors, although you know we're past deliberations in the guilt phase, but that rule applies now too at this time. Don't talk to each other about this point in the trial until you go back to deliberating the case. But because of the vast media attention that this case has attracted, I want to be absolutely sure to reiterate to you, although I think I've got the message clear once again, in an abundance of caution, please don't talk to anyone about the case. And I appreciate that you are following the court's instructions in that regard, so that you base this part of the proceeding only on the evidence presented in court that you've already heard in the guilt phase of the trial and that you will be hearing during the sentencing phase. Before we get started and I give you instructions about this part of the proceeding, I do want to tell you in advance, give you an idea of logistically, procedurally, how we're going to be going forward over the next 2 days. And my primary goal there is to assure you that our intent is to submit this case to you for your decision tomorrow afternoon. Cases at this juncture involve great logistical challenge that are beyond the control of the attorneys. They do the best they can, but witnesses will be called who are either at or coming from very far away places, and you all are aware of what is involved with travel. So therefore, what's going to happen this morning, we're going to have some very brief testimony this morning. We're going to break. We're going to start this afternoon at 1 o'clock. We're going to have some testimony this afternoon. And then after that, we'll break. We'll come back tomorrow morning, have some testimony in the morning. And then the goal would be to submit the case to you with arguments and instructions on the law in the afternoon where the case is submitted to you. The reason I'm telling you that is I anticipate some of these breaks could be significant beyond what we would normally have done during the guilt phase. So I just want you to be prepared for that, and also not to concern yourself with it, just to be patient. But I think it'll help you being patient if you know the grand scheme as far as when the case will be submitted to you, which is tomorrow. So I believe your participation in this matter will be ended tomorrow afternoon. That's the schedule. So now that I've explained that, members of the jury, you have found the defendant guilty of 1 count of first-degree murder of Tanya Wise and 1 count of first-degree murder of her unborn child. The only issue before you in this phase of the trial is to determine the appropriate penalty as to these crimes. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. As you know, what the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you heard during the guilt phase of this trial, is presented for you to determine whether the state proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case as to both victims are: 1. As to both victims, that the defendant was contemporaneously convicted of another capital felony. This is based on the conviction as to the victim involved in the other count. As to both victims, the capital felony was committed for financial gain. That's number 2. Number 3, as to both victims, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The term cold means the murder was the product of calm and cool reflection. The term calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. And aggravating factor number 4 relates only to count 2, the first-degree murder of the unborn child, and that is the victim of the capital felony was a person less than 12 years of age. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Mitigating circumstances. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released, and you will begin your deliberations. You should not form any definite or fixed opinion until you've heard all the evidence, the arguments of the lawyers, and my instructions on the law. Once again, until that time, you should not discuss the case among yourselves or anyone else by any means whatsoever. Your decision must be based solely on the evidence or lack of evidence and the law. The same rules and procedures regarding your possession and use of cell phones apply to this phase of the trial as well. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room, and you cannot have in the jury room any cell phones, computers, or other electronic devices other than those that we would provide to you as we did in the guilt phase. Once again, you must not conduct any investigation of your own. The same rules continue to apply. Just as in the guilt phase of this case, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. We now begin with the opening statements of the attorneys, and the state may proceed with its opening statement.
Here we go. Opening
Morning,
statements.
everyone. All right, so as you've already found the defendant guilty of first-degree murder of Tanya Wise and first-degree murder of what would be her second son, the defendant's fifth child, Josiah Wise. And as the judge just explained to you, all of the evidence that was introduced during the guilt phase applies in the penalty phase. So all of the evidence that you learned, all of the testimony, that all applies in this case, and if you need to bring it, it'll go back with you again if you need it. So what is the first step that we talked about? And this goes back to jury selection. The state has to prove each of the aggravating factors beyond a reasonable doubt. And what you'll see when you go back and you think about the evidence that from the guilt phase applies to this case is that has all been proven. Each one of those have been proven by beyond a reasonable doubt. And the judge talked to you about 4 different factors. 3 of them apply to both victims. And when we talk about both counts are independent of themselves. The defendant can get a death sentence on both counts. He can get a death sentence on one or the other. He can get death for first-degree murder of an unborn child, or he can get the death sentence on just Tanya Wise. He can get life on both counts. That's your decision. But what the evidence that was presented in this case already shows is that each and every one of those aggravating factors has already been proven beyond a reasonable doubt. And when you use your common sense, it's pretty clear. Because what's the first one? Contemporaneous, there's a capital conviction. Both of the murders you've already found him guilty of. That's what that factor is. It's been proven you've already found him guilty of both murders at the same time of both the victims. That factor's been proven beyond a reasonable doubt. What's the next one? Financial gain. How has that been proven? He told us, in the garbage truck. I'm going to lose everything. I'm going to lose it. He needs to stop this before he has another child. It's going to ruin his marriage. It's going to cost him money. There's a potential for there to be a separation. He's got a new child to take care of. He wanted to eliminate the possibility of his wife finding out and the existence of him having another child. He did this for a financial gain. He tells Eric Alvarado days and times over and over again, what is his situation? It's been proven beyond a reasonable doubt. The fourth one that applies to just the victim, once again, you use your common sense. You think about this, the victim was less than 12. We know the gestational age of the baby. She was 8 months pregnant. Once again, the evidence that's already been presented in this case proves that beyond a reasonable doubt. So when you go back there, the first step should be those 3 easily proven beyond a reasonable doubt. What is the last one? It was done in a cold and calculated and premeditated. And the judge, he defined those to you. Cold is a cool, calm reflection. Let's go back to the garbage truck video. He planned this out for days, over and over again. He drives around in his garbage truck discussing, should I do it this way? Should I blow her brains out? Should I choke her? Would it be easier to get it done with one blow and be done with this? They look at many different spots of where he's going to dump the body. Is anyone going to find her out here? He thinks about what her life is like. No one's going to be looking for her. He talks about how he's going to lure her out there. It's all been proven beyond a reasonable doubt. Any one of the 4 aggravating factors in and of itself can justify the death penalty if you go through the whole process and you follow the laws instructed by the judge. All 4 of them can, but each one is independent of itself, and the first step is, do you find that there are aggravating factors? And the evidence shows yes. All 4 of them are there. Now, do those aggravating factors justify the death penalty? Yes. I encourage you that they do. And when you go back and you look at all of the evidence in this case, you look at the aggravating factors, you consider the mitigating circumstances, the appropriate sentence is the death penalty in this case. Thank you.
Very quick open, just a couple minutes, about 5.
Mr. Burns.
Thank you.
Thank you.
Ladies and gentlemen of the jury.
Little fist bump there between the prosecutors.
I have waited long to address you, but more about that later. The state will, I think, likely prove, probably already has, that this killing was done coldly and calculatedly and premeditatedly. I think they're going to prove that to you. So I think you probably will have an aggravator in your pocket. And I think regarding the victim, Josiah, who looked in the autopsy photos so much to me like a newborn baby, I think you're certainly going to find that he is under the age of 12. And this is the opportunity where I will tell you what the mitigators will be and what my witnesses will be and who they will be and what they will say, and I would love to tell you all about it, but I don't know. Since the conviction, many of my witnesses have melted away. They won't be here. Victims of their own moral cowardice, in my opinion. I could compel their appearance by subpoena, but I'm here to beg for a man's life, and I don't want people in the witness chair who don't want to help me do that.
This is nuts.
So I can't tell you exactly what's going to happen beyond this afternoon. This afternoon, I will present a witness. His name is Raul Banasco. He is an expert in prisons, in the Florida prison system. He's worked in Florida. He's worked in other states. And he will tell you about the prison system and how Jose will fit into it. If you do vote to condemn him to death, I think your knowledge and common sense tells you that he will exist as a prisoner for years until that happens. And if you should vote for life without possibility of parole, then he will exist in prison forever and ever. And Raul Banasco will tell you how that might be, so that you have a fuller picture there. You will also hear from a lady who knew Jose a long time ago, knew him well, knew him intimately. She will come in and testify. She, at least, is not afraid of what people on social media might say about her. She will come in difficult circumstances and tell you a little bit more about Jose. That's all I have for this afternoon. The judge mentioned travel problems. That's my witnesses. We have a problem wrangling them and getting them here from Connecticut. I do expect that we are going to have some of Jose's family members arrive this afternoon in Palm Beach. We will speak to them this evening. The state will have a chance to speak to them tomorrow, and you will hear from 1 or 2 or 3 or maybe all 4 of them tomorrow. I'm not sure how many are actually going to get on the plane. And so I don't want to leave you in a mystery. I wish I could tell you who's going to be here and what they're going to say, but you and I will learn together probably. But the thrust of the matter is that you will have plenty of mitigators to consider. And because I am missing witnesses, will probably alter and enlarge some portions of my intended argument that will be addressing what it might mean to you, and how you will make your moral decision. As you have learned in jury selection, it's your own personal moral decision. I'm going to offer you, how about that, some guidance in that way. So you will hear some witnesses for the defense this afternoon. I think you will hear from some of Jose's family members tomorrow. And then I think you're going to be making your decision or retiring to deliberate about it at some point tomorrow. That's all I have for you right now. Thank you.
Thank you, Mr. Burns. And the state may proceed with its case.
Yes, sir. The people of the state of Florida call Elizabeth Bedolla.
Here comes Mom again. That was crazy. That was almost a beg for sympathy because people won't support him.
Do you swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
This is the victim's mom taking a stand right now. Finally gets to speak about the impact this had on her. This is probably going to be a tough one.
Good morning.
Good morning.
You've testified before, but go ahead and state your name for the record and spell your last name, please.
My name is Elizabeth Bedolla. It's Bedolla.
Okay. And again, just for the sake of clarity, go ahead and state your relationship with Tanya Wise.
Tanya was my daughter.
Okay. And did you prepare a written victim impact statement?
That's correct.
Okay, I'm going to show you what has been marked as Court's Exhibit Number 1. You recognize this statement?
Yes.
Is that the statement that you prepared for the jury today?
Yes.
Okay. When you feel like you're ready, please go ahead and read that statement to the jury.
My name is Elizabeth Bedolla, and I am the mother of Tanya E. Wise and the grandmother of her unborn son, Josiah Thomas Wise. I am here to speak about the loss of my Tanya and Josiah and how their death has forever changed my life and my family's life. Tanya was lovable, caring, a devoted mother. She had a beautiful soul
and was always willing to help and take care of her family. She enjoyed being a mother more than anything in the world. She loved spending time with her son Jamar, playing with him, cheering for him in all his events, and making sure he always felt loved and supported. Tanya was so excited about becoming a mother again. She always spoke about giving birth and how great of a mother she would be once more. She had so many dreams for Jamar and Josiah, dreams of raising them, guiding them, creating happy life together. Those dreams were stolen from her, from us, from the child who will never have a chance to grow up with his loving mother. Every memory with Tanya was special. I clearly remember the last time we were together as a family. Her stepdad, her son, Tanya, and I went to the beach. We laughed, we played, we had so much fun. It was one of the happiest days we had together, and I will cherish it forever. Another beautiful moment that I remember was her baby shower, surrounded by family, celebrating new life that we were waiting for to welcome. Those were the last 2 times we had with Tanya. That were memories I will hold on in my heart for the rest of my life. The emotional impact of losing my Tanya and Josiah is unbearable. I cannot sleep at night. When I do, the nightmares are horrific. Birthdays, holidays, and even simple dinners bring so much emptiness, loneliness, and pain because she's not there. I'm unable to function properly at work or in my daily life. I miss her so much, my baby girl. She was my baby girl, my only girl. And losing her has broke me in many ways I cannot explain. The grief is overwhelming. I live in constant pain, not only in my body but also in my heart. A heart that never goes away. It never goes away. I'm angry. I'm angry because I don't have Tanya and Josiah here with me to love and joy and share my life with every day. They should have been here. Instead, I'm left with grief, sadness, and memories. That anger is part of my pain and it will never leave me. I still have problems accepting that she's gone. I catch myself thinking that she will be here with us tomorrow and that I hear her voice or see her smile. But tomorrow comes and she's still not there. That reality is crushing and it's something that I struggle with for the rest of my life. Her son Jamar, who was only 8 years old at the time of her mother's murder, misses his mom every single day. The sadness and the trauma that this has caused him is something no child should ever have to carry. Jamar struggled with the loss deeply, and it breaks my heart to see him growing up without his mother's love, guidance, and presence in his life. Our house was one full of laughter and energy, and it's now quiet. Tanya was the life of our home, with her smile, her joy, and the way she played all around with Jamar. Now the light is gone, and our home feels dark and empty without her. The pain is not mine alone. Tanya's stepfather, her son, brothers, grandparents, aunt, uncle, and cousins are all suffering as well. Many of us are battling depression, trauma, PTSD because of this tragedy. Our entire family has shattered, and the weight of the grief follows us every single day. The stress of losing Tanya and Josiah has also affected my health. I have heart condition. It has grown worse because of the grief and the stress I carry every day. This tragedy has taken serious toll on my body, broken. It has also broken my spirit. And it's not just me. It has also taken physical and emotional impact on our son, Jamar. I grapple daily with the loss of Tanya, his mother. I wonder how the future will be. And I wonder how Jamar will grow up without Tanya. And how our family will find a way to live with this emptiness. Nothing feels certain anymore without her. The future we imagine is gone, and we're left trying to survive in a world that feels hopeless and broken. Tanya has already missed so much, and she will continue to miss every important milestone in Jamar's life. She will not be there for his accomplishments, his graduation, even his wedding day one day. She will never get a chance to hold her grandchild. These are moments that should have been hers as a mother, but they have been stolen from her and from all of us. Nothing can bring Tanya and Josiah back. The future we dreamed of, the milestones, the celebrations, the simple everyday moments have been stolen from us. I will never see my daughter raise her children. I will never see my daughter raise her children. And I will never get to hold my grandson. Our loss is permanent. And it has changed me and my family forever. The depth of our pain and devastating impact of this crime has had on me and my family the most important, but most importantly, my grandson, who will now be come into a life without a mother, is simply unfathomable. We will live with this grief for the rest of our life. What happened to my Tanya and Josiah will affect me forever. And I don't know how to live without her. She was my baby girl, my only girl. I will carry this pain every single day of my life. Nothing will ever take away this grief, the anger and the emptiness that their loss has left me behind. In the end, 2 innocent lives have been stolen from us. and we will never fully recover from this loss.
Ma'am, I want to show you what has been marked as court exhibit, photo composites, court exhibit number 1. Are these 30 photographs of Tanya that show her throughout her life?
She has to look at the pictures to authenticate them so they can be admitted to the jury. So this is concert card. These glasses make my eyes all sweaty. Does he have a friendship bracelet on?
Yes.
Okay. And do all these photos show Tanya at various stages of her life?
Yes.
Okay. Your Honor, permission to publish?
Any objection to introducing the item and publishing it?
No, Your Honor.
Those items will be introduced into evidence and published.
Defense will not question beyond possibly saying I'm sorry for your loss.
Good.
And you may step down. And the state's next witness.
I guess other people say the Florida called Tracy Hamill.
Let's see. Hold on.
Does she need to be sworn?
I don't know who the witness is or what your plan is, so it depends on.
Victim advocate who's going to read several victim impact statements.
So she would not be sworn at this time. She's going to simply be reading a statement of another person. Okay.
Yes, sir.
It's not sworn testimony. She can simply read the document.
Ma'am, can you state your name for the record and spell your last name?
Tracy Hamill, Hamel.
Okay, and what do you do for a living?
I'm a victim's advocate at the state attorney's office.
Okay, and as part of your duties as a victim's advocate, do you sometimes read prepared statements for those people who may not be in an emotional position to do so for themselves?
Yes.
Okay, I'm going to show you what has been marked as Court's Exhibit Number 2 for identification purposes. Do you recognize this?
Yes.
Okay. What is that?
This is Lenora Bedola's victim impact statement.
Okay. Can you go ahead and please read that to me?
Yes. My name is Lenora Bedola. I am Tanya's stepsister, as well as her best friend. I am here to speak on behalf of myself, my family, and the loss we have all suffered since Tanya and her unborn child Josiah were taken from us. Tanya was a loving mother, a hard-working woman, and a bright light in all of our lives. She had an incredible sense of humor that made everyone around her feel at ease. She was so smart and resourceful, always looking out for others and putting them first. But above all, Tanya was my safe person. She was the one that I could confide in, the one who always knew how to make me laugh or comfort me when I was struggling. I told her everything, my joys, my worries, my fears. Not being able to speak to her anymore has left a hole in my heart that nothing can fill. Since her death, I have cried every day. I wake up with the ache of her absence, knowing that my kids will never get to spend time with their TT Tiny. We won't be able to go to the beach together again or share simple moments like going to the mall or eating out with our kids. I moved to Florida for the summer just to be closer to her, hoping we could make more memories, and now I'm left with the empty space she once filled so effortlessly. The pain of not having her here is unbearable. I miss the small things, the smell of her hair when she got out of the shower, her smile, and the warmth of her hugs. These are things I will never get to experience again, and it hurts more than I can express. Life is not the same without Tanya. It will never be the same. There is a constant weight of sadness in everything I do, and I feel lost without her by my side. She was a part of my everyday, and now that part is gone. This profound loss that has shattered our family. Tanya was not just a victim of this crime. She was a daughter, a mother, a sister, and a friend. Josiah, her unborn child, was a life we all looked forward to, and his loss is felt deeply. We are left behind with an emptiness that words can barely capture. I will carry the pain of losing Tanya with me for the rest of my life, but I will also carry the love she gave. She was taken from us far too soon, and nothing will ever fill the void she has left.
Thank you. I'm going to show you what's been marked as Court Exhibit Number 3. Do you recognize this document?
Yes, I do.
What is that?
This is the victim impact statement for Michael Reveron.
Okay. Can you go ahead, please read that when you're ready?
Yes. My name is Michael Revron, and I am the proud older brother of Tanya Wise. Tanya wasn't just my sister. She was one of the strongest, most caring people I've ever known. She had this rare gift of being the life of the party wherever she went. Her laugh was loud, her smile was real, and she had a way of lighting up a room just by walking in. But beyond all the fun and energy, she had a heart full of love for her family and friends. Even though I was the older brother, Tanya always acted like she was my second mom. She looked out for me in ways I didn't always notice at the time, but I feel every day now. She would show up at my job just to take me out to lunch. She would also come to my job just to spend time with me, sometimes staying for hours just to talk, laugh, and be together. She always offered support, encouragement, or simply a listening ear whenever I needed it. Some of my favorite memories are the simple ones. We used to go to the movies together, just me, Tanya, and my nephew Jamar. We'd laugh, share snacks, and just enjoy being around each other. That was our thing. It was peaceful. It was fun. Birthdays and holidays still feel empty, even after all these years without her laughter and presence. What used to be moments of joy are now constant reminders of what we have lost. Losing Tanya has left me broken in ways that are hard to write. I feel anger, sadness, and emptiness all at once. I feel like a part of me is missing. I struggle to focus and to move forward because so much of my strength and happiness came from her. Even as her older brother, she made me feel grounded. Some days I find myself grabbing my phone trying to call her to tell her about my day. On top of the grief, I now live with PTSD, depression, anxiety, and nightmares because of what happened to her. I relive the pain over and over in my mind, and some nights I wake up shaking and crying. It has taken a serious toll on my mental health, my sleep, and my ability to function day to day. The future has been forever changed without Tanya. I think about all the milestones she will never get to experience. She will never see her nieces and nephews grow up or witness all the things they will accomplish. She will never meet her grandchild. She will miss the wedding we always joked I'd never have. I will never get to meet my unborn nephew or see all the great things he would have done. For me, I will never again have my sister, best friend, to share memories with or to laugh with. Her absence leaves a void in my life that can never be filled. I hope that by sharing who Tanya was and how she lived, that the court understands the depth of loss. We're not just grieving her absence, we're grieving everything she would have continued to be: a loving mother, a joyful sister, a loyal friend, and a light in our lives. This isn't just about the life that was taken from Tanya and my unborn nephew, but the lasting impact their loss has had on me, my family, and all who love them. No words can fully capture the pain, emptiness, and grief we carry every day. Depth of our loss knows no bottom or end.
And I'm going to show you what has been marked as Court Exhibit 4. Do you recognize this document?
Yes, I do.
What is that?
It's the victim impact statement for Reyes Bedolla.
Okay, and when you're ready, can you go ahead and read that quickly, please?
My name is Reyes Bedolla. I am the stepfather of Tanya Wise and the grandfather of her unborn son, Josiah Thomas Wise. I would like to talk about how much I miss them and how hard it is to live without them. Tanya was amazing, funny, helpful. She was a bundle of joy. She was a loving, caring, and devoted mother who loved to play around with her son. Everywhere she went, she would smile. She was always there giving a helping hand to the family. She touched everyone with her kindness. We had built a strong bond. I knew her dream and what she wanted to do with her life, and I was going to be there every step of the way to support her. Her life was about her children and raising them. Losing her in this way has left me with a pain that never ends. I looked forward to welcoming my grandson Josiah into the world, but am now heartbroken as I have to come to terms with the fact that this will never happen. All I am left with are dreams of what he would be like today. Every time I see somebody else with a child, I imagine my beloved grandson and wonder about the things that could have been. I would have loved to watch Josiah take his first steps, play sports, and grow into a man. I will never hold him, play with him, or even spoil him, and he will never call Grandpa. I am so hurt my life will never be the same. I am raising Tanya's son Jamar, and I see how he suffers for his mother. This emptiness that my family and I can never be filled. I ask myself, why are Tanya and Josiah? We struggle to move forward every day. I remember going to the beach with my wife, Tanya, and her son Jamar. It was all about spending quality time together, and we all planned our future. Our conversation were all about family. I don't have this anymore. I have never been able to go back to a fun day at the beach as our family feels like we are not complete and are broken, and we are trying to piece it together to continue our next day. Our family is struggling to move forward while trying to honor their memory. Nothing will ever be the same.
Thank you.
You're welcome.
Thank you.
Wow. And the people of the state of Florida call Johnny Reveron.
So if you raise your right hand and please support.
Please swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, it's Johnny Reveron. Last name's Reveron.
Okay, and did you know Tanya Wise?
Yes, she was my sister.
Your sister, okay. I'm going to show you what's been marked as court exhibit number 5. Do you recognize this?
Yes, sir.
Okay, is that the statement you prepared?
Yes, sir.
Okay, when you're ready, go ahead and read that to the jury.
Yes, sir. My name is Johnny Reveron. I am Tanya's older brother. I stand before you today to speak not only for myself, but for my family and for Tanya's unborn child, who was never given a chance at life. The loss of my sister has devastated every part of my life. Tanya was not just my sister. She was my friend, a piece of my heart. She was carrying her child with such joy and anticipation. That child should be here with us, loved and cherished. But this life was taken before it even began. Just a month before this tragedy, Tanya and I spoke after she started working at the same company where I work. We talked about her excitement for this new chapter and how much she was looking forward to building her future. I never imagined that it would be one of the last meaningful conversations I'd have with her. Since her murder, my world has been turned upside down. I wake up every day with a heavy heart, knowing I may never hear Tanya's laugh, see her smile, or share the simple everyday moments that brothers and sisters are supposed to have. Holidays, birthdays, and family moments are now filled with pain because Tanya and her baby should be here with us. This tragedy has not only caused unbearable emotional pain, it's left lasting scars on my family's sense of security, stability, and peace. I struggle with grief, anger, and unanswered questions. I have lost sleep. I have lost hope. And I will carry this pain for the rest of my life. Tanya and her baby deserve to live. They deserved a future full of love and opportunity,
Instead, what remains is a permanent void in my heart and in my family's life. Thank you for allowing me to share on how much I miss my sister.
Thank you, sir. Thank you. People in the state of Florida call Yaritza Irizarry.
Just raise your right hand and please repeat.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And for the witness.
Morning.
Good morning.
Can you state your name for the record and spell both your first and your last name, please?
Jaritza Irizarry, Jaritza. Last name Irizarry.
Okay. And did you know Tanya Wise?
Yes, she was my niece.
Okay. And I'm going to show you what has been marked as court exhibit number 6. Do you recognize that document?
Yes, I do.
Okay, is that the statement that you prepared to deliver to the jury?
Yes.
Okay, when you're ready, go ahead and read that to the jury, please.
Your Honor, my name is Jaritza Irizarry, and I am the aunt of Tanya. To me, she was more than a niece. She was like a daughter. Tanya was a beautiful, loving young woman whose life was taken from us in the most painful and senseless way. Her death has left us a permanent hole in my heart and in the heart of my family. Tanya was a devoted mother. She loved her son Jamar with everything she had, and she was overjoyed to be pregnant with another baby Josiah. Not long before her murder, I hosted her baby shower. I could still picture that day, glowing with happiness, surrounded by her family, smiling as she opened gifts for her new baby. She was so full of hope for the future, so excited about raising her children, and so ready to begin a new chapter of her life. But that joy and that future were stolen from her, from Jamar, from all of us. Jamar has to grow up without his mother, and Josiah never even had the chance to take his first breath. Her loss has shattered our entire family. My sister, her mother, is broken. No parent should ever have to bury their child, and watching her live with this pain has been unbearable. Every holiday, every birthday, every family gathering feels incomplete without Tanya. There is always an empty chair and a silence where her laughter should be. For me, it's the everyday moments I miss the most. We shared so many simple joys together, taking the kids to the beach, going shopping, eating out, or just cooking her favorite meal. I miss sitting with her, talking and joking around. She had this way of making everything seem better. No matter what I was going through, at times I wanted to pick up the phone and call her to tell her everything, like what I always did. But now there is only a silence. Those ordinary times that once brought me comfort and happiness now feel heavy and empty without her. The pain of losing Tanya has affected me deeply, both emotionally and physically. I cry without warning. I struggle to focus, to find joy in the things I once loved. I suffer from sleepless nights, nightmares, and anxiety. The grief sits in my body like a weight, leaving me exhausted and drained. A part of me died with her, and I will never be the same. The crime didn't just take one life, it took two. Tanya's life was taken, and so was baby Josiah's before he ever had the chance to live. Jamar lost his mother, my sister lost her daughter, and I lost someone who was like my own child. Our family has been torn apart, and the pain we carry will never go away. Respectfully, Charitza Irizarry.
This is a remarkable string of family members who are showing just the close-knit family that they had.
People say Florida called Jamar Bedolla.
Their grief is palpable. They're extremely eloquent in sharing it.
So if you can raise your right hand, please.
Please swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Yeah, over that way to witness.
Morning. Can you state your name for the record and spell your last name, please?
Jamar Bedolla, Bedolla.
Okay. And what is your relationship to Tanya Wise?
She was my mother.
Okay. I'm going to show you what has been marked as Court's Exhibit number 7 for identification purposes. Do you recognize that?
Yes, I do.
Okay. Is that the statement that you prepared?
Yes.
Okay. When you're ready, can you go ahead and please read that to the jury?
Hello, I'm Jamar, and I'm the son of Tanya Esther Wise, who was taken from us. My mother was the closest person to me, and she was like my best friend. Also, she was always there for me. I'm here to share a few to honor my mother and talk about how I was affected. Ever since that day, Ever since that day, there have been many different ways that I've been affected emotionally. For example, I've developed depression, sleeping problems, and anxiety. Losing her made me grow faster than I should have. I used to hide my pain and try dealing with it on my own, and to protect myself from getting hurt more than I was, and I didn't like talking about what was wrong with me. Every day, I think about how she won't be able to see what I've accomplished and what I will accomplish in the future. She's already missed some of my milestones that I've reached, and I think that she would have been proud of them. I wish that she could have met my first girlfriend and watched me perform in my musical performances for my school. I'm in marching band. My mom was also musically inclined. She played the clarinet, and I hope that she would be proud of who I've become. On that day, I've lost more than a mother. I also lost the chance to have my mother watch me grow, and I hope that she's proud of me for coming here and talking about how this has affected me. I choose to honor my mother because she was one of the most, if not the most important people who has been in my life.
Thank you. That will conclude the evidence from the state.
Members of the jury, that concludes the state's part of the evidentiary portion of this penalty phase. As I mentioned, we're going to break at this time till 1 o'clock. Please remember the rules regarding communication. Don't discuss this case with anyone, including your fellow jurors. Enjoy your lunch, and we'll reconvene at 1 o'clock. And please leave your notes on your chairs.
A long 2.5-hour lunch for the jury. In what I would say is a remarkable series of statements, the family has shown a unified front and a unified love for Tanya Wise. As many of you mentioned in chat, Jose, when he was planning her murder, said that this would be easy because no one would miss her and no one would look for her. Not one of the family members mentioned Jose or even referenced him.
Can this be 1A? Can I make this 1A?
What was one?
One with her.
But all of them spoke of Tanya and
yes, going to make the 1A now.
And what a light she was.
Some of these items I think came into evidence, but some were just court's exhibits. Is that right?
Yeah, all of them.
They're all courts exhibits. So what I mentioned before, as far as the other one coming to evidence, just strike that. They'll all be courts exhibits. Okay. All right. And anything else for us to take before we break and come back at 1 o'clock?
Not from the defense, Judge.
Okay.
Nothing from
State. All right. We'll see you at 1 o'clock, and we have the Zoom working. I emailed you the message about the interpreter being here tomorrow. She's going to be here, Miss Bellivier, so that should not be a problem at 8:30. And enjoy your lunch. We'll see you at 1 o'clock.
All right. So the family. We've got more family members here today, clearly, than we had during the trial. During the trial, only the mom was consistent all the way through. Defense takes their coats off. Their work is done here. Aside from closing arguments, they've successfully prosecuted this case and put on just an amazing. Let me speak briefly about the statements. First of all. We have seen some very powerful victim impact statements come out of Florida for very many reasons. We've seen victims who are just emotionally and physically and just crushed by the devastation and the loss that they feel, which I think this family fits into every one of them. We've seen victims who are angry. In other cases, who are just mad at the system, mad at the defendant, or the convicted, the murderer at that point, and have been eloquent in their anger as well. The way the law is written in Florida and the purpose of victim impact statements, this is the way the law intends them to be. This is the proper method, although sometimes we see and cheer for and support and understand victims that are angry, that want vengeance, that want to even the scales in a way. The law says this is how victim impact should be. The statement should be about the impact that the loss of the victim caused on the surviving member of the family or friend. So this family nailed it. I mean, we're talking poster child for how victim impact should be done. Just amazing. Really, really powerful and touching. It is so hard, as many of you know, to put grief to words, right? It's so hard to put a sentence to capture the devastation that you feel, 24 hours a day in your soul, and put it in a paragraph. But they did just that, and used examples to show it. It was just stellar, unbelievable. I think that is going to have a powerful effect on the jury as they go forward with this next step. And none of them made a recommendation. None of them said to the jury, I'd like to see him rot, or I'd like to see him, lose his life the way, my daughter didn't have a choice about when hers ended. None of them said that. It was very, very amazing. And these glasses are making my eyes super sweaty. And to think that, you look at the contrast. Look at the contrast with Jose, with what he tells us, with how he views this. This Tanya being pregnant with his child is an inconvenience to him, and so he thinks he can just discard her and throw her away, so he doesn't have any problems. I look at the contrast to how Tanya's family viewed each other and supported each other. And we're there for each other. Just night and day difference between the two. All right, we have a little bit of a break. Because we have a break, it's a 2.5 hour break. We're not going to take a full 2.5 hour lunch. We're probably going to do a little bit of court hopping. Then we are going to take a lunch, and we'll come back with the afternoon session, which probably will be short. because defense only has 2 people to call today. The rest are flying down or are potentially flying down. So I'm not sure how that's going to go. There's a likelihood that not all the people that the defense thinks are getting on the plane will get off the plane or even get on in the first place. Holy cow. Whoa. Hang on. Sorry. Red Pen, thank you. Let me go back. I just saw that. Holy cow. Let me go back and start where I left off. Wow. Natalie O. Gifted a membership. Thank you very much. Wallflower, 31 months. OG. Good morning to you. Nicole Watson, member for 12 months. Love being a part of this community. Thank you, Nicole. 12 months of support. That's awesome. You hit the year mark. Let's see. We've got Kathy Mazak. Kathy, member for 25 months. OG, loving the pink. Hit the like button. Everyone, thank you, Kathy. Unholy Saint. Also an OG with 28 months of support. Watching from Arizona. Glad to be here. Chris Wallace, gifted a membership. Thank you, Chris, for your generosity. SM Casey, member for 28 months on the jury. Why is he not in jail, Tyre, since he's been convicted? Thank you, Casey, for that. I think we answered that question. If you still have a question, let me know. We'll try to address it again. Let's see. Lulu, member for 26 months. OG, usually quiet, but love this channel. Lulu, thank you very much. Congratulations on 26 months. And Lulu, you went on and gifted another membership. That is super generous as well. Thank you. Great Grinder, member for 31 months. This is an OG. Thanks for Ari and mods and the great community here. Great Grinder, thank you. And Tammy E, gifted 20 memberships. Oh my goodness. Tammy, your generosity, that is huge. Thank you so much. Peter Ware, member for 29 months. OG. Tough day to have a milestone. It is, but what a great community to be part of. Tumwater Troy, also member for 24 months. That's 2 years, means Pink Courthouse, member of the jury. OG, Tumwater Troy. Sorry for talking bad about your town in that court yesterday. We struggled in that one. It needs to redeem itself. I know it can. 2 years, wow, best place to be. Thank you, Troy. Micah, member for 31 months, says, love you, all right. Micah, thank you so much. 31 months makes you also an OG. There we go. Wow. Wonderful membership milestones rolling in right now. Y'all are amazing. That is so cool. I want to see if I can see all those. Oh, I can't go back. Who got all the gifted memberships? I missed it. I was focusing on the thing. I'm sure they're wonderful people all around. Thank you very much. That is super generous. I missed it entirely. I was not watching. It was a day of love here, very much so. Your emphasis on OG kills me, says Mike. I don't know how else to say it. As a matter of fact, I can't say it twice in a row, like close together. I have to space them out because I lose the ability to do that. I don't know why. You've seen me butcher it a couple times. All right. And Ali G in UK says, in case anyone would like some silly positivity, my cat just tried to follow me down the fence line to the neighbors to collect the plate. I have the cake on. She doesn't let them pet her, so cats are crazy. I love them. I just tried to reach my glasses, and I don't have them on. Okay. You have to go to Judge Dad. Back 1 hour and 17 minutes or so ago. Look in mod chat for who we're looking for. Well, tell you what, Josh, I'm there. I'm there right now. Let's go back. You said 1 hour and 17 minutes. Go a little more than that. 1 hour 17 is about right here. Okay, so it's got to be the red shirt.
Turn it 4 weeks, Lisa.
You're putting in the market.
Case.
I don't know what you guys are talking about. That's up to you two. If she's happy, I'm going to be happy. But you got to have rental property registered. Give me the date, Lisa.
It's
October 22nd at 8:30.
We're waiting for
October 22nd at 8:30 in the morning. You'll go down the hall, sir. You'll get your notice, and we'll see you back here then. Any questions?
No, Your Honor.
Good luck. Robert Thomas Boyd, 25B82557.
Yeah, I'm going to try to shrink in this corner here so you can see everybody. That work? Not taking too much space, Judge.
Your name?
Robert Thomas Boyd.
Before we go on, I'll be happy to provide you with a lawyer if you want. This is a review hearing.
We're wearing the same color.
No, sir.
You waive your right to a lawyer.
I do.
Name?
Statement for Attorney Brown Township.
Rob Harris, Inspector Brown South Township.
Please tell me he did what I told him to do.
As of yesterday at about 2 p.m., no.
Nothing?
Nothing. The property looks worse.
You're going to force me to do something I don't want to do, Mr. Boyd.
I've done a lot of work out there.
Okay, let me just go through this with you then. Okay? I ordered that the garage must be torn down and removed from the property on or before September 15, 25, and the undersurface filled to grade level. Did you do that?
No.
I ordered that all non-permitted accessory structures be removed from the property. Did you do that?
What structure would that be?
Remind me.
It's like the mobile home.
Right.
You use as storage.
Rob was supposed to give me a phone number, a place that takes RV.
Why don't you tell me what you've done? I ordered you to have all vehicles on the property licensed and operable, and that they had to be located on a concrete or asphalt driveway surface. When I read these to you, you can interrupt me. You can stop me and say, Judge, I did that. Did you do that one?
No, sir.
I also said all inoperable vehicles have to be stored inside an enclosed building or removed from the property on or before October 1. Did you do that?
Partially.
I also ordered that all recreational vehicles have to be operable as well as licensed and registered to the owner or occupant of the property. Did you do that?
Yes, sir.
Did he?
I have no proof of that. I've called for inspection, no return call, and never.
Recreational vehicles must be stored on hard or pervious concrete, asphalt, permeable grass, pavers, or gravel surface. Recreational vehicles have to be used for their intended purpose and not as storage. Winter boat storage is only permitted on residential waterfront surfaces and therefore not permitted at the property. Junk, trash, rubbish, tarps, anything that creates rodent harborage or refuse of any kind needs to be removed. The weeds, grass, and undergrowth must be cut and maintained so as not to be higher than 8 inches. And I also ordered that prior to the review hearing of actually today or September 26th, I said, defendant is to permit Brownstown officials on the property for a compliance inspection. Did you allow them? Did you call there?
Yes.
Did he call you and he never called you back? Why didn't you do that?
Didn't get it.
Listen, Mr. Boyd.
There are some circumstances here I'd like to tell you about.
Mr. Boyd, I'm going to listen to you. But it's not like this just started. This has been going on for, as I understand it, how long?
Well, there's opens for over a couple of years, and then I took it on like at least 8 months ago.
And the property's getting worse. I went out there. I didn't want to touch anything. I want to listen to what you have to say. I'm going to shut up and let you talk. Tell me whatever you'd like to tell me.
Well, I'm chairman of the Wayne County Canvassing Committee. We had an election. That was 2 weeks. Every day. When you have an election, Birthdays don't count, holidays don't count. We have to be there every day for 2 weeks.
When was that?
It was trying to think of the date.
Well, 2 weeks, but I ordered this.
Yeah, well.
I ordered this back on July 30. This is September. So since July 30, just to do some quick math for you, we've had 32. We've had 56 days. So even if you were tied up in some kind of an election, for 14 of those, you still had 42 days.
Yeah.
What else? What else? I want to listen to your extenuating
I
circumstances.
had a family reunion that was put on me and I didn't know about.
Mr. Boyd?
That was 4 days.
You've had 2 years. The property's junk.
I'm working on it.
No, you're not.
Yes, I am.
That'd be like, no, you're not.
I got the boat out for sale up near the road. I got,
Now you're going to tell me it's bad weather and you can't do this stuff. I don't know what to do with him. I'm going to be completely candid. I don't know what to do. Because he's not going to listen. He's not going to comply with the orders.
Yeah.
He's not defiant. No, you're not. No, you're not. You're not going to comply with orders. You're going to give me every excuse under the sun. And this can't go on. It just can't go on. And you're going to force me to put you in jail today. And I don't want to do that.
I don't want to go.
I feel like I've begged you to do these things and you're not doing them. And then last time I got a little more forceful and I ordered you to do it and you haven't done anything.
I'm working this.
No, you're not. No, you're not. Come on. Don't lie to me. I don't like people that lie to me. I think there's nothing worse than a person that stands in the courtroom and looks a judge in the eye and lies to them. This is, I don't know what to do with you. I don't know what to do with you other than jail you, because I'm not going to get your attention. You're going to give me every excuse under the sun. Reunions, elections, 2-week election for a canvas presidency or whatever you do.
Every election is 14 days.
I just don't know what to do with him anymore. It's fully Carter. Am I supposed to put him in jail or am I supposed to just let him defy orders? That's basically my options here.
I am working on it.
Why didn't you call him back?
Oh, I didn't get.
Why didn't you call him back?
I didn't get it. I didn't get his call.
Did you leave a message? When?
It's been probably 3-4 weeks, but I've been out to the property. I mean, I drive by it probably at least twice weekly. There's been no guy.
I knew this was going to happen.
That work.
I knew this was going to happen. I just knew this was going to happen. I was 1,000% positive that this is what was going to happen, and I was going to have to sit here now and decide, do I let in gentlemen like Mr. Boyd, and you are a gentleman, defy orders repeatedly, or do I send you to jail? And I don't think I have an option.
I need more time.
You're going to serve 5 days jail starting today, sir. It's first technical. I'm sorry, that's what I'm doing. Defendant to serve 5 days jail forthwith. And
Hard to do any work from jail.
listen, I'm going to make a promise to you. You do this again, you're going to be sitting in there over Christmas. I promise you. I'm not playing games with you. That's a junkyard. You have neighbors. They don't need to have that blight by their house. My God, who would buy a house anywhere near there? I don't know what else to do. You're in custody for 5 days. Good luck. We're going to set another review. Lisa, give me another review hearing date in a month. If you don't have it done, sir, I'm telling you, bring your toothbrush and 85 pairs of clean underwear. Do we understand one another?
I do.
Good. Okay, new review hearing date, and you're going to allow him access too the minute he's out. The minute you're out, you answer his phone calls. I'm sorry, Lisa, go ahead.
October 22nd at 8:30.
October 22nd at 8:30.
Yeah, before, can I just double check what Mr. Boyd's phone number is?
What is your phone number, Mr. Boyd?
I can tell you it is 123-867-5309. That's our Sesame Street fake phone number. It's not a real one for the YouTube algorithm.
Mr. Boyd's had problems with ordinance since I was in middle school, as far as I'm concerned. This continues to happen. This citation was issued back in April. We've been running around with this. It's not only the neighbors and the blight issue, it's also the dangerousness of the building, especially that garage. He hasn't taken out any permits or anything of that nature, so he's had no intention to comply.
No, I've just heard excuse after excuse.
That happened for me.
And I knew.
Demolition permit, but you have to at least have the building inspector out there to make sure that the structure can come down, if there's electricity there, and what the plan is. So you can't just demolish it and have everything sit there. So that you'd have to have a plan at least at minimal approved by the building inspector for any demolition.
But he told me that.
Mr. Boyd, listen. You brought this on yourself. I don't want to do this.
Yeah, he never informed me about that.
I know, it's their fault. I don't want to hear it.
The city wants to go in and clean it up. But Mr. Boyd will spend the next 5 days in custody. The city's going to end up cleaning it.
You gentlemen have a case ready. What's your name, sir? I'm sorry? Okay.
Yeah, he's a problem with the town calling.
If I was a neighbor, my family would pitch in and help this poor guy. The neighbors want it cleaned up. He is refusing. And you heard the prosecutor say, this has been going on since I was in middle school. She's like, I was in 7th grade when this citation was first issued. They've been fighting and fighting and fighting to get this cleaned up. And now, for the first time, he's doing 5 days incarcerated. It doesn't fix the problem. It's trying to get his attention, as if he didn't have the attention of him before. It's
J. Edward Clay, 25I-76087C.
Eventually, it's going to come to that, Martha.
Sorry. Your name? J. Edward Clay.
He does need help. He probably needs somebody with connections to explain how to do each thing. But the hard part is agreeing to let things go.
Were you here on September 10th as well?
Places that will take a car donation.
So we adjourned it. I thought you guys were going to have a resolution, but you didn't resolve it?
No, sir. There's a couple of entities involved. My homeowner's insurance, they wanted me to mention something, and the homeowner's insurance told me just to hold on and get another lawyer so I could work with that work. So I contacted the Bar Law Association, and they're supposed to be getting back with me the next day or two.
Okay, I want to be clear. I'm adjourning this 2 weeks. You're going to have a lawyer, okay?
That's fine. I just,
Adjourn?
enough time.
Sure enough.
I didn't know it was that hard to like.
All right, we're going to jump.
Get a response.
We're going to Judge
October
Boyd.
8th, Lisa?
We're jumping.
Yeah. A campaign manager. So I have campaign managers come talk to them, and I tell them, hey, unless all of the stars align, you're not going to start off being a campaign manager and making $2 million. But they've enjoyed it, and they always enjoy the trial advocacy portion, because I would have some people say, I want to be a prosecutor, or I want to be a defense attorney. And I said, so defense attorney, you want to do solo practicing? They're like, yeah. I said, it's not like The Good Wife where everybody is walking around in Armani suits, having dinners.
You got to pay overhead.
Yeah. And getting the client who comes in and says, represent me on this state jail felony. Here's $200,000. I'm like, doesn't happen. But they always enjoy it. And then they get, I do my best to get them internships wherever they're interested. And I try to get them paid internships. Ooh, because
those are good.
Yeah. But for the campaign and election law course, I always tell them they can sign up to be judges because they get paid. I want to say it's $15 an hour. So I have somebody come speak to them about that. Because it's hard. It's hard for poor students. Yeah. Every little bit helps.
Judges speaking my language.
So that's what we'll be discussing tonight.
Good on you, Judge.
All right, thank you. Yeah. Well, you know, you say that, but let me just tell you right now, your name is on my list for the trial advocacy and appellate law. Yeah, I'll say, come in, speak to them.
Come speak
Tell them
to
what
the
you
students.
do.
Jose's got a little break until 1 o'clock. We'll be back there.
I actually had a former prosecutor from Puerto Rico to speak to them. And so he came, he spoke to them. He said in Puerto Rico, it's different from here because he was actually a prosecutor here. He said in Puerto Rico, you're supposed to go out to the scene with the officers.
Like as a prosecutor?
Mm-hmm. And I know there are some other states and other jurisdictions, the prosecutor actually gets called and they're on call and they go out to the crime scene.
I had seen that where there's like nighttime CID,
Mhm.
CTV that goes out there with the on-site, like homicide.
Yeah.
I think that's, it's good. It adds more integrity to the case.
Well, he said, one, it's hard when you get the call at midnight and you got to roll out of bed to go do it. But he said, you're able to tell officers sometime, hey, did you get this witness? Go talk to them or whatever. So it's always interesting. In every class I learned something new. So that's always great. Who? Who's he looking for?
Rob Anderson.
Oh,
I'm here to help as a second chair.
Oh, for
Mr. Anderson.
oh, he is in. I think he's in the jury room.
Oh.
Yes. You're welcome. I think he's watching something with one of the prosecutors. Just knock on the door. It's the 187 jury room.
He's watching some evidence.
My biggest critique of law school.
Mm-hmm.
Biggest critique of law school.
Complete absence of real world education of practice.
Mm-hmm.
Like, here's the theory. Sure, I could have learned that from a book. I didn't need to spend $200,000 to learn it.
Mm-hmm.
You could learn everything that is in a book. What you really need to learn was practically file a motion. This was before like e-file, right? Everything e-file, but like how to go and just
See, you know what? That is why.
Intimidating to walk into this whole world without any prior notions.
Well, you know what? I started doing criminal law CLEs for the San Antonio Black Lawyers Association because people would label things as, oh, Crim Law 101 Foundation. And I said, no, I said, if you're doing foundation, do foundation as though I have never stepped into a courthouse. Can we do that foundation?
Exactly.
And so that's what I started doing. But you were a leg up on me in law school. So anyway, in law school, I couldn't afford books. So I went through all of law school with no books.
What?
Which turned out to be a great thing. And let me just tell you why it was a great thing. I would look at the syllabus, and on the syllabus, it would tell you what case you're talking about. So what I would do is I would go to the library and I'll be like, man, this case is 500 pages. Because I read all of this, I read the entire decision and I read it from the trial court level all the way up. And that really helped me a lot because I had a chance to understand why the case was decided the way it was. So it turned out to be the best. But yeah, I didn't have any books.
Law school with no books. That is amazing.
So I would just learn what cases the professor was going to talk about. Then I go to the library and I would read the case. And then I would come back and the teachers would be wondering, oh, she doesn't even have any books. What's going on here? All right, who's here for Oscar Correa Hernandez? That's fine, Joe. All right, if y'all come forward, please.
I think we're going to jump to Judge Simpson here in just a second. Let's hear this first case. Got a translator. That's why the headphones. The defendant has headphones. Translator speaking to wireless.
All right, the court is calling 2025 CR 007803, State versus Oscar Carrillo Hernandez. Can I have parties announce?
Jerry Kagan on behalf of Oscar Carrillo Hernandez.
And are you Mr. Hernandez?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, Your Honor.
All right, and if you'll state your name for the record.
Jacqueline Payan.
All right, you can lower your hand. Mr. Hernandez, all of the documents that I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
All right, and Mr. Kagan, do you speak Spanish?
No.
All right, and were the documents explained to your client in Spanish through the interpreter?
Yes, they were, Judge. We went through it meticulously.
Okay. And counsel, have you received all discovery and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We'll waive it, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Carrillo,
So
Mr. Carrillo Hernandez, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
He most certainly is.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Anyone promise you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
Yes.
And counsel, I noticed on the document, have you addressed all immigration issues with your client, or is there anything you need to put on the record?
We have, Judge, and my understanding is that he also consulted with an immigration attorney.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's $1,000 fine. State recommends deferred adjudication, and there's to be drug testing. Did you understand that to be the plea?
Yes.
And I say drug testing, I mean restitution for the testing of the drugs. Did you understand?
Yes.
Defense is at the plea?
Yes, Judge, and I explained that to him over in the witness room as well.
All right, state is at the plea.
That is your understanding.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
None.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours community service restitution, and random UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State officer states one in his question.
I've reviewed those documents with my client. We have no objections.
He's
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand?
We're gonna mute her for a second. We're gonna jump over to Judge Simpson and see what's going on in his court.
I expect payment. Thank you.
Thank you.
Court calls case People versus Nicole McCauley. Both cases.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. McCauley. Ms. McCauley, please say your name for the record. Nicole McCauley. Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions, and we do ask that you adopt the probation's recommendation.
Anything you want to tell me before I impose that?
I apologize about wasting your time.
I'm not wasting my time. I get paid. All right. In case ending in 0597, sentence of the court, $125 statutory fee, $1,750 restitution to JSG payable through the court. I'll order 365 days in jail. Credit the 272 you served. The balance is suspended on that case. I'm presuming that after these cases, she's not going to be released.
Yes, these are the last things holding her. She's on probation in Wayne County. She's been on a writ here, but she's been in custody for quite some time. She was in Wayne County, then Oakland County, I think back to Wayne County, then here.
Yeah.
So she's not working. So she's going to need some time to.
Yeah, the $1,750 I'll just make due and payable by December 31st, 2025. And so let her get out, get settled, and try to make sure to try to arrange something regarding that. On the other matter, the case ending in 0111, on count one, the larceny less than 200, I'll order $125 statutory fee, 93 days in jail, credit 93 served. On the count two, 200 larceny 200 to 1,000, $50 statutory fee. I'll reserve restitution for a period of 60 days. 300, and I'll order 365 days in jail, credit 272. The balance is suspended.
Thank you.
All right, thank you. Court calls the case People versus Michael Kyle.
Mr. Kyle, who may be present via Zoom.
Michael Kyle.
There's a little doubt there. Bench warrant.
Your Honor, I believe this was today set for state review, but I believe it was a show cause. I believe his balance is $360. The numbers I did have for him, unfortunately, are all now disconnected. I did send an email to the last email address I had for him, but other than that, I don't have further explanation for his failure to appear for the record request and adjournments.
Bench warrant will issue bond 5,000, 10% privilege. Warrant will issue immediately. Court does call the case of the People versus Michael Patterson. Did they go back? What happened?
See who it was, though, Your Honor.
They dragged home. I would have held whoever.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Patterson. Please state your name for the record, sir.
Michael Lee Patterson.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Patterson, and we do not have any material changes or corrections. I've also had the opportunity to review the recommendation for sentencing with Mr. Patterson. And although we do understand that Mr. Patterson is asking that he be released today and be sentenced to credit for time served, he states that he does reside at the Delana Center, and he is asking if Your Honor would allow him to be released today to go reside back at the Delana Center. Other than that, we would ask the court to adopt probation's recommendation.
Sir, anything you want to say before I impose sentence?
No, Your Honor.
On count 1, indecent exposure, $125 statutory fee. Defendant is to submit a DNA sample. I'll order 365 days in jail. Credit 194 days served. Defendant is to serve the balance. On the count 2, indecent exposure, $50 statutory fee, 365 days in jail. Credit 194 days served. Defendant is to serve the balance. Thank you.
Sorry.
Court calls the case People versus Francis McMullen.
Teresa Clare on behalf of probation. Your Honor, Ms. McMullen was scheduled before the court today for a review hearing on a prosecutor-deferred sentence. She did complete all terms ordered by the court, and I did waive her. Probation's recommending that the court dismiss the case pursuant to the prosecutor-deferred and discharge from probation with improvement.
Hearing no objection, so court. Court calls case People versus Javier Ruda.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ruda, who stands to my right. Please state your name for the record, sir.
Javier Ruda.
Thank you, Your Honor. It's my understanding this is set for a show cause hearing, and it's my understanding there is still a balance. Mr. Ruda is being held on other matters. He has a preliminary exam scheduled for the 30th of this month. I'm asking for an adjournment of the show cause of this case, Your Honor.
I'll adjourn this to November 12, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the People versus Jerron Wilson. Pardon? Unless I'm seeing.
I'm sorry. Good morning. Assistant Public Defender Lauren Kearney on behalf of Mr. Juan Wilson. Who's scheduled to wait? Claire on behalf of probation, Your Honor. Mr. Wilson was scheduled for the court for a review hearing on a prosecutor deferred. He is compliant with all terms ordered by the court. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with no objection.
So ordered. Better for that?
Yes.
Okay. Then what I'm going to do, we were running a little bit behind because of our interpreter cases. I'm going to take a brief break, let them get set up for that one, come back up momentarily, and begin the 11 o'clock. Court stands in recess.
All right. Court stands in recess. All right. Let's see. We've got a little bit of time to kill before we go back to the Jose Soto-Escalera trial in Florida. That's going to pick up at 1 p.m., which means we've got about, let's see, hour and a half now. It's a long lunch. So we might see if we can find just a little bit more to watch before we begin Let's see. Look at this one. Let's see if 44th District Court is doing anything. Judge Ulrich or Urick.
So if you get some unusual numbers coming in on any device, please answer. They're going to try to help you. So anything that comes from a 248 or maybe even a 313 is someone looking to help you.
Unless it's a spam call.
Your next court date in this matter is called a probable cause conference. So you will get a notice directing you as how to appear to that probable cause conference. That notice will go to Taft Avenue. You got to make that court date. If probable cause is either found or waived within the next 21 days, this matter could be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. Now, Mr. Jackson, the court does need to turn its attention to bond. That's not intended to prejudge or punish you, but it is required in order to ensure that you do reappear for your case and that you pose no threat to the public. Mr. Steinberg, the court doesn't see any significant CCH or contacts with respect to Mr. Jackson. What would you like to share?
Your Honor, as the co-defendant, he appeared here on time. I advised him because you shared information with me that I didn't know from the previous arraignment, namely of what brought the police attention in this case. The only contact to Michigan was the Dream Cruise. He is from Cleveland, Ohio.
We're gonna jump again. Judge Middleton has another show cause.
Find that you are in contempt.
Let me back up. We don't know who's in contempt yet. Show cause zoning ordinance, probably a very similar case to what we just saw with Judge Dad. Is he lawyering in a t-shirt from his couch? Hey, if the judge allows it. We've got to get as much Middleton time in as we can with him being a little over a year more
All right,
or
we're
so.
back. Let's go back on the record. We return to our hearing in Colin Township versus Alfred and Joanne Yoder. File number is 25040CZ.
We're not going to start another one.
Testimony portion of this hearing has been completed.
Soto's done.
Court's heard testimony under oath. We've received 6 exhibits, and I'm going to give each of the parties an opportunity now to argue what they think should happen. Mr. Thornton.
Yes, Your Honor, and my comments will be relatively brief. The Yoders made a decision to not participate, essentially, in this case when they should have participated in it and had the opportunity to participate in it and be heard. They then, after the court's default judgment and permanent injunction entered, and it's very clear that they were aware of that default judgment and permanent injunction. It was served upon them. They knew what it said. They then, because they disagreed with the decision, they intentionally kept violating the order. It is very obvious from March 13th through now, and from the exhibit entered on the number of births out there, that the births could have stopped much sooner. than they did. And I'm not sure from the testimony given by the Yoders that they intend to permanently stop them at this point, but I guess we'll see on that. My point is that the Yoders' contempt, and I think they are in contempt of Judge Stutzman's and this court's order, was intentional. And only from the township's persistence in getting to this hearing are we here today in almost the end of September. So the township is going to request a fine under MCL 600.1701. Actually 600.1715 of $3,500 per defendant.
Wow.
To get the point across.
$7,000 fine?
The circuit court's orders are that and need to be followed or legally contested.
And pay the original $243. Now I have $2,000 of bond money, which I can allocate toward fines and costs.
Yes, we still want the $248 or whatever it was. And my understanding, the township gets none of that $7,000. So I would request, and the statute does provide for restitution to the township. I'm not prepared today to submit a detailed accounting of how much extra cost the township was imposed. I understand the township's not going to get its attorney's fees for the entire case, but it seems unfair to the township to the missed hearings, the appearances I appeared for, the motion and order to show cause proceedings,
He wants some money.
Impromptu unscheduled hearing when the Yoders unexpectedly showed up at the courthouse, and in today's proceeding. I would like to request to the time to submit a request for the court's consideration to award restitution directly to the township for some of those extra fees and costs that they incurred.
That's generally called a bill of costs. As you know, I often, in fact, usually give any fine money to the township as restitution rather than keep it to the county. Zoning enforcement's expensive. If a policeman charges someone with a crime, with drunk driving, the county pays for the prosecutor, the county pays for the judge. It doesn't work that way for the townships. If the township proceeds to enforce an ordinance, the township pays for it. And if there's a lawsuit, there was a lawsuit in my township that cost the township about $25,000 in attorney fees, and they lost. So my practice is often to just give any court fine money that would go to the court to the township to offset the cost of the case. All right, so you're asking for $3,500 per defendant. The maximum would be $7,500. And that I allocate that as restitution, but we need a bill of costs and a further restitution hearing. All right, thank you.
And the 248.
And the 248. And as I indicated, I've got $2,000
This is a zoning violation
from their cash bonds that they posted. All right, Mr. and Mrs. Yoder, their contention is that you violated Judge Stutzman's order by continuing to have births at your center. Now let's repeat.
It's a birthing center case.
You changed the name of the enterprise from Mama's Birthing Center to Mama's Ministry. And it is a ministry. I guess I won't deny that. It's part of an overall worldview of things. But the ministry or Mama's Birthing Center wasn't charged. You were. It's in Alfred Yoder and Joanne Yoder's name. So as Mr. Thornton argued, that name change is irrelevant, but it isn't really that easy. People do that. They're sued on a debt. They owe somebody money, and they change the name of the company and say, well, I don't owe the money anymore. That company doesn't exist. Maybe that might work sometimes if there's a corporation or something. The other thing people will do is they'll transfer the property to somebody else for $1. Somebody's got a horrific toxic waste site, and the township pursues enforcement, and they transfer it to their granddaughter for $1 or something, and argue we don't own that property anymore. Sometimes we have to parse that out. At any rate, this action is against the two of you. Judge Stutzman ordered back in March that you not have any more births at that center in terms of a permanent injunction. Doesn't matter what the name of it is, you can't do this at that place. And you had births through April, May, June, July, September, and I'll take it at your word that there weren't any births after August 29th and none in September. Obviously, your place is, well, if we've had 87 births in 5 months, you're busier than some of the hospitals. I suspect there weren't 87 births at Sturgis or Three Rivers Hospital during that period of time. At any rate, they did present sufficient evidence that you've continued to have births there in violation of that order of March 13th. So I find that you are in contempt. They're asking for $3,500 to make the point. I think the point is going to be made with the cost to the township of doing this. So we will set a hearing regarding the sanction after you submit a bill of costs. My inclination is to reimburse the township for their costs. That may be enough of a sting. And as I said, I do have $2,000 that I can apply to the fine and the contempt. I do fine beyond the required standard. The township has established that you're in contempt for continuing to hold births through the summer at this facility. Now, let's talk about what happens next. He ordered that you can't do this there permanently. You don't agree with that and have not agreed with it, and you have a right to disagree with it. What you don't have the right to do is to continue to do it. If you continue to do it, they're going to file a petition for criminal contempt, in which case I can put you in jail for violation of the order. I could order under the equitable authority under the zoning law that the facility be torn down. I don't want to do that, and I don't want to put you in jail. I want you to stop. What you need to do, you obviously have a constituency. People like your service. I heard a number of people get up at the county commission meeting and say that we need this, we want this, and why is the government messing around with this? So you got people that want your service. You need to do it somewhere where you're allowed to do it. There are places that you could cite this that would not be in a zoning violation. The township says you can't do it here. That wasn't up to me. They filed the action. There was a hearing. Judge Stutzman made a ruling. Again, you had an opportunity to participate in your defense, but you didn't. So now we're all stuck with the order. You can't do this here. This isn't an order. But my recommendation is find some place where you can do it. And your followers will find you. We're going to set a second hearing regarding the amount of the fine.
If you build it, they will come.
And Mr. Thornton will provide a bill of costs. You'll have an opportunity to object to that. Then I'll make a ruling on how much the fine is. We can set that for Wednesday, October 15th at 1:30. Does that work for you?
It does, well. You said 1:30?
Yes. Mr. Thorne, I'd like you to do an order stating that the court found that the plaintiff had met their burden of proof and the defendants were found in contempt. And the court intends to order a civil fine or restitution. And they will set a hearing on the amount of that fine for Wednesday, October 15th at 1:30. All right, we now have to deal with the other case. Yes, Ms. Yoder?
For the Judge Stutzman hearing, I still feel that was very much, considering we had notified them, we had given them information about this is a private ministry, and being that would be totally out of their jurisdiction on doing anything like this against a private ministry before they made a court hearing. They had all this, and then Judge Stutzman lied about it. He said that we attempted to file our paperwork and we did not. We did, it's all proven fact, it's stamped, it's dated. It was done February 6th.
Well, you can appeal these. His ruling has been made and you did not move to set the ruling aside or appeal it. So it stands. If you had some defenses that could have been raised, they weren't. Now, a higher court, higher than me, may have a different view of it. So it's difficult to appeal a case to the Court of Appeals. I've done it, and you'd be very, very difficult for you to do this without legal counsel. And they're probably going to uphold his ruling. So if you want to continue your ministry, my suggestion is you find a place to do it where it conforms with the zoning regulations. Then you can continue with your ministry. Your clientele can still utilize your services, and you'll be in compliance with the law. All right, we have
just a
the preliminary injunction. We're going to shift the record here to the next case, which is file 25533CZ. That was the default judgment that entered. Request for default was filed by the clerk. What's the date of this? It's filed August 23rd of 2025. And I did a preliminary injunction order in that case, which I'm pleased that the Yoders have attempted to comply with that since my order of August 29th. The order that Judge Stutzman entered had a reasonable time in it. That time is passed. So the date is September 1st. And that date is passed, but there should be no further operation of Mama's House at this location after September 1st, 2025. So we're going to take out the reasonable time requirement. The people after that date have found other remedies. All right, let's shift to the new case, Mr. Thorne. That request for default was submitted. I haven't seen any response. What's your position regarding that?
Your Honor, I would like to call one witness, the township building official, to put on some brief testimony that would add a little bit to the admissions by the Yoders to the complaint, to each allegation in the complaint. And then I would request at that point, once that testimony is received, the entry of the proposed default judgment I submitted in this case.
Mr. Yoder, would you come forward again?
Actually, I don't.
I mean, Mr. Klein, I'm sorry.
Actually, it's Lance Bonifield.
Oh, all right. Mr. Bonifield, would you come forward?
Raise your hand and be sworn.
Good morning. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
And would you state your name?
Lance Bonifield.
Could you spell that for us?
LANCEBONIFIELD.
Mr. Thorne.
And you're employed by whom?
Safe Built.
And again, Safe Built has a contract with Colon Township, correct?
Yes.
To provide building code official services.
Colon Township.
Inspections. Okay.
Colon Township does inspections.
Are you the present person that does that in Colon Township for
Yes.
Safe Build and Colon Township?
Yeah, I do plan reviews and building inspection.
And are you familiar with the Alfred and Joanne Yoder's property commonly known as 30246 Marsh Road?
YouTube's been really greedy lately.
Fairly recently built quite large structure on it, correct?
Yes.
Approximately a 6,400 square foot structure.
Wow.
Yeah.
It's good size. Bet they built it quick too.
As part of preparation for today's hearing, I asked you to review Safe Built's entire file on this property. Is that correct?
Yes.
Did you do that?
Yes.
It's already established by the pleadings, the verified complaint and the failure to answer those allegations have been admitted that 2 stop work orders entered on this property. Is that your understanding?
Yes.
The first one entered on February 2nd of 2024. Is that correct?
Yes.
And the second one entered on April 8th of 2025. Is that correct? No, you didn't post those stop work orders. Somebody else with Safe Built did. Is that accurate?
Yes.
But you know that information from reviewing the file?
Yes.
In your review of the file, can you tell us whether either of those stop work orders were ever rescinded or terminated by Safe Built or Colon Township?
No, they haven't been.
So they are still in place.
Yes.
The postcard. Wish you were here.
Having reviewed Safe Built's file on this matter, can you tell the court whether building inspections have been conducted on the structure located at 30246 Marsh Road?
The only inspection performed there was footing inspection.
Should there have been other inspections performed?
Yes.
What is the kind of the status of that building?
Well, several inspections haven't been done, and I saw that when I went there. We should have had framing, insulation, whatever trade happening there, roofing and final.
Plumbing.
Those haven't been done.
Haven't been requested by the owners. So therefore the structure has not been inspected.
Yes.
What state?
All right, let me start. That includes electrical, mechanical, plumbing inspections?
Correct.
If we went out there today, what would we see? What status is that building in? How far along is it?
Final. It would be complete. The last time I was there was to post some documents on the door, and there was some siding that wasn't done and some site work that wasn't done.
But you viewed the inside of the structure through windows, is my understanding?
And it's drywalled and the flooring is in.
Peeping Tom.
Complete.
And there is no and has been no building permit on this building for quite some time, correct?
Correct.
The former contractor that pulled the building permit terminated the permit, correct?
Yes.
In your opinion, or do you have an opinion as to whether this structure as built and as viewed by you the last time you were out there, is it built as a home or is it built as something else?
It looks like a healthcare facility to me. I opened up the drawings and looked at the floor plan. It looks like patient care rooms.
Is there a kitchen?
No kitchen. It's not in the drawings.
SJ just
That's all I have, Your Honor.
5 memberships. SJ, thank you very much for your generosity.
Again, that's in addition to all the verified allegations in the complaint that are considered admitted at this point.
Is there plumbing and bathrooms in the facility?
I'm not sure. I've never stepped into it.
Are they in the drawings?
I don't recall. All I looked at was the floor plan.
All right, thank you. Mr. or Mrs. Yoder, do you have any questions you wish to ask?
Yeah, I've got a little bit of a question on the affidavit for a search warrant. The fine, or whatever they want to call it, is signed by Lance Bonifield. And from the FOIAs that were requested, he's got no valid oath of office. And if you go back to the Attorney General, he's got no right. It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue or serve occurrence tickets upon persons who violate the building code or the zoning ordinance of a city. It is my further opinion that the city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or charter provision.
I hope he wins on this one.
What's the name of that opinion?
That's an affidavit for a search warrant.
No, the Attorney General opinion you just quoted from.
Frank J. Kelly.
Yeah, but what's the name of the parties?
Delta County v. City of Gladstone, 305 Michigan, 50.8 NW 2D 908, 1943.
Amish citing case law. I hope he wins this one.
County of, what county is that?
On that same.
What county is that?
PA.
Delta County v. City of Gladstone.
Also known as Happy Rock.
On the same affidavit for search warrant, it's a prosecuting official, Lance Thornton. I thought he's an attorney. I think he's running 2 different deals on the same. And then if you go back to the search warrant.
And he doesn't have a legal oath of office either.
We've got the officer as Lance Bonifield. If he's got no oath of office, he's an officer. So I'd say that whole thing's null and void.
I hope they win this. I really, really hope they win this.
All right.
I've got motions here. I'd like to have for you and Lance to have one of these.
Yes, would you hand them to the bailiff?
This is like the truest form of soft sit here. The Amish are amazing people. To have them facing prosecution for not building something right is absurd, right?
Yeah.
They build stuff better than anybody
Respond
else.
to what he said.
Well, you can ask him questions. We're not to the argument part yet, but if you have a question for him, you can ask it. Otherwise, I'll give you a chance to speak when we get there.
I'll just wait.
All right, this is, I'll get a date stamped by the clerk. I'll just put filed, bench file. 9/24/25. I guess it's entitled Motion to
dismiss for lack of jurisdiction, a violation of constitutional rights.
Okay.
Introduction. Defendant.
No, you don't need to read it all. I've got it here.
This is organic soft sit. I love that. The Amish have been building buildings and doing it remarkably
Again,
well
there's a timing
for a
issue.
long time.
They filed this lawsuit. You had 21 days to respond. It did not respond.
We filed special appearance papers.
That's not an answer to the complaint. And then the time to answer has passed. So
as far as the responding date, so we did start getting things together to respond within 21 days. And then we were served more papers on this all being changed from Judge Stutzman down to you. And there was no response timing on that form. That's why we got a response on the date of the hearing with our special appearance forms.
Reverend Beasy got it. Thanks.
Mr. Thorne, what's your response?
The court rules provide that once the defendants are in default, which they are, defaults have been entered against both Mr. and Mrs. Yoder for failure to respond with an answer to the complaint recognized by the Michigan court rules, that they no longer can participate in the defense of the action until that default is set aside. And that default has not been set aside. It's so I would object to any consideration of this motion filed here today. Is one, it's not a motion to set aside the default, and it's not been filed timely and was not served upon me and the township in time to respond to it. We can't be expected to respond to something we're given during the hearing. This case has been pending quite a long time also. The whole jurisdiction issue and this oaths of office, they've cited some of these arguments before. The statute they're relying upon, which is MCL 85.10-16, is Fourth Class City Act.
Yeah, the case that they were quoting from is a city case, not a township case.
And I believe the court's aware that there are different statutes and acts in Michigan that govern cities and townships. And I will represent as an officer of the court that the Fourth Class City Act does not have anything to do with Colon Township. The Michigan Constitution, Article 11, Section 1, really requires any official that is a legislative, executive, or judicial officer to be an oath of office. A building a code official in the state of Michigan is not an officer either of the legislature, executive branch, or the judicial branch. And there is no state statute that I am aware of that requires a building code official to take an oath of office. And I know the Michigan Township Association backs that up.
Mr. Bonifield, you can step down. I'll accept this for filing. We'll set it for a ruling. Again, I got it like 3 minutes ago. I haven't read it. I'll make a ruling on it on October 15th at 1:30. You may proceed with your motion for entry of a default.
Your Honor, based on our motion and the admissions in the verified complaint by having no answer filed, and the additional supplemental testimony given here by Lance Bonifield today, I move for admission of the default judgment and permanent injunction that was submitted with the township's motion and brief in support of that motion.
I was looking for the order. As I indicated, these are circuit court pleadings and their on-base system is different than mine. Do you have a copy of that order with you?
I do, Your Honor. I have an extra copy of the default judgment.
I got a copy of the August 29th order.
And the orders were provided with that proposed judgment when they were served with the motion. It has not changed from that date.
I wonder if the Amish were treated more like an Indian reservation.
By order.
Where they can do some of their own policing and rules, if that would be a better solution.
Order part. It is hereby ordered the plaintiff's verified motion for entry of default dated September 12th, 2025 is granted. The above finding of facts are hereby incorporated and made a part of this judgment. The defendants and their officers, agents, servants, employees, attorneys, assigns, or successors in interest, or anyone involved in participation with the defendants are permanently enjoined from performing any further work on the interior or exterior of this building being constructed on the subject property unless a valid building permit is issued for the building by the building code officials and the stop work or orders have been rescinded by plaintiff's building code officials. This is common. This happens all the time. The case right now when someone built a garage, and I don't know how well built it is, but they didn't get a permit. Or they build a house and don't get a permit. You'd be amazed how often that happens. At any rate, I order that. You're enjoined from occupying the building or allowing anyone else to occupy the building unless written authorization is obtained from the plaintiff's building code officials. If an occupancy permit is granted by the plaintiff using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and or pregnant women as a place to give birth in return for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. Plaintiffs, I'm going to put in here rental room or fees or donation.
This order is trying to cover
Plaintiff
all
shall
the
cause a
bases.
certified copy of this judgment to be recorded in the Officer of Register of Deeds for St. Joseph County within 30 days of the date of the entry of this judgment. No money damages are awarded to Colon Township. Defendants are ordered to pay $304.38 in taxable costs in relation to this motion. They shall be paid within 30 days from the entry of this judgment. The permanent injunctive relief granted in this judgment supersedes the previous injunctive relief granted in the preliminary injunction order dated August 29th. The court retains jurisdiction of the case to enforce the terms of this judgment. From what I saw, that looks like a nice building, and it does look like a medical facility. I'm sure it could be used for something, but it can't be used for a birthing center. I'm going to accept this filing and this filing. I'll ask that the clerk date stamp these and provide a copy of this permanent injunction to the defendants. You have a right to appeal this, but there's a process that is to be followed. This one's a thornier issue. My recommendation is you simply continue your ministry at a different location. A lot of money was spent building this building without a proper permit and without inspections. And we had a case several years ago where a church, they did a large bunch of construction without inspections or permits. They got the girders up to support the church and they didn't match. It was a big mess, and eventually it was rectified, but nowhere in the county can you do this, build a building without permits and inspections. So that's my order. I would ask you to go up to unless you want me to just mail it to you, I'd prefer to give you a copy today. Could you guys process this and bring a copy back down for the defendants? All right, you give those to us.
Your Honor,
Yes, Ms. Yoder?
I would like to reappeal both cases.
All right, you can do that, but you can't do it by saying I appeal. Any more than you can say I divorced you 3 times and be divorced. You have a process you have to follow. All right, Mr. Yoder?
Just for the record, I guess, so you know, we had a building permit, we had a foundation permit, we had a zoning permit, a well permit, a septic permit, mechanical permit, and a plumbing permit.
Well, that was my understanding that it started out, it was permitted.
Now, why, if they give me the permits, they had the prints that they could see exactly what that building is. They knew exactly what the square footage is of that building because it's right on the permit. I've still got copies of the permit. Once the building is all built, they say you can't do that. The thing of it is, Mister, when we got to the point, my wife said, we got to do something different. She's going to need a new building. I said, all right, you go up, you find out what we need. Because the only place I can put a new building is in 2 acres of woods. So I'm going to have to clear 2 acres of my woods so my wife can put a house in there. I said, I'm not clearing woods before we've got permits. Ain't happening. So they give us all these permits. She talked with Joe from Safe Built and told him what she wants to do. And he told her how to fill out the permits. Okay, so we had the permits. The building is all enclosed. Yes, it's not going to weather from the outside. But all of a sudden they say, oh, you can't do that because you need this and this and this and this. Explain that.
I don't know that I have an explanation. I agree. This was started. You didn't just show up in the dark of night.
It's totally uncalled for.
All right. The problem is they filed the action, the default entered, and now you raise your defense.
We filed personal or special appearance papers on every court case
All
that
right,
was filed.
so you have this concept of oath of office and special appearance papers. The court didn't accept those as a pleading. As again, you need legal help, real legal help, somebody with a license and some understanding. And I would encourage you to continue to get it. You've got a not what looks like the bones of a very nice building there, but you can't use it for the intended purpose. And you're right. They let you start this, and then somewhere along the line, the wheels fell off.
Well, how can they do that?
I don't know, but they just did.
Yeah.
So, all right, we're going to be in recess. This matter is completed. You wait here. They'll bring you a copy of the order. You have a right to appeal it. We're going to have a further hearing on October 15th, where we'll determine what the penalty is, and I'll have an opportunity to review your motion and rule on it. If you want to file anything else, you can file it and schedule for hearing on that date. All right, we'll be in recess.
All right, we have one more we have to jump to. That's a frustrating one, hearing that they started. Let's see, where am I at? That's the wrong one. They started with permits and then sort of lost them for some reason. Let's see, Kansas. This is Josh's. Kansas 13th. It's Judge Webster. We need to go back a little bit. A little bit further. A little bit further. Not so far. Here we go. Quick one from Judge Webster, and then we're going to go to lunch.
Hey, that's all I have here at the courthouse, Judge.
Ruby's doing her
Jose
fingernails.
Ramirez, what's going on with you? Are you about to pass out there or what?
Well, first of all, my name is Brock Collins. I'm not Jose Ramirez.
Well, why'd you put Jose Ramirez on your screen?
That was, Your Honor, that was my fault. I had two defendants with the same exact Samsung name. And so when I asked in the waiting room who the defendants were and to give me their first and last names, the Samsung responded and said it was Jose Ramirez. So I have Jose Ramirez in the waiting room still, but Brock Collins hadn't given me his name yet. I just had two with the same name.
I see. All right. Well, maybe I ought to get the other one in here and let Mr. Collins wait a while, but it looks like he's only half with me, so maybe
No, I'm here. I'm here with you. I've just been waiting patiently.
All right. Well, let's see. We are on the record in 2002, 24-3024, State of Kansas versus Brock E. Collins, Jared Regier for the state, defendant in person and pro se. Mr. Collins, you've filed a motion in this case on your own behalf, and let's see, you originally were charged back in September of 2002, speeding 93 and a 70.
2002?
And driving without insurance.
93 and a 70.
And then...
2002. We're talking 23 years ago? And it's just now going to court?
I don't know what happened after that, if you paid the tickets. But then May 14th of this year, it says you called and wanted the court to find through a hardship program that I should go back and, well, you just tell me, go back and what, waive your fees?
Well, what I'm trying to do now, ever since then, my license has been revoked, and they just came up for reinstatement. The revocation has been uplifted June the 6th of this year. And in order for me to get my license back, I'm trying to get all these outstanding fines that I had. I'm trying to get them all taken care of. And so far, I've done that. And you happen to be the last one that I have to get, that I want to get taken care of in order to get my license back.
Okay.
All right. And I do see you have suspension fees of $586. Well, that I think includes your fines and costs. plus your reinstatement fees, $586.
You say the suspension, you say suspension fees or reinstatement fees?
Reinstatement. Yeah, they're reinstatement fees added on to the fines and costs that you didn't pay. Mr. Regier, what is the state's position on this? Have you seen a copy of his motion?
Your Honor, with all due respect, the state did file a response to this motion.
Yes, and I started to read that earlier and I got sidetracked by something or someone. Would you summarize your response, Mr. Regier?
Yes, Your Honor. The state's first position is that this motion is not properly before the court under KSA 6C205A1D. Pursuant to the same, except as otherwise provided in this chapter, each of the following papers must be served on every party, a written motion except one that may be heard ex parte. The state specifically notes in its response, although the state acknowledges that the defendant's motion does include boilerplate language for a certificate of service, such boilerplate language includes neither a purported date of service nor any purported recipients of the motion, nor does the motion include any attached documentation in support of any attempts by the defendant at serving the motion on the Butler County Attorney's Office as required by statute. So the state's first position is that this motion is not properly before this court. The court finds that the motion in the alternative is probably before this court. The state acknowledges that pursuant to KSA E1 and E2, a person who is assessed a reinstatement fee or a fine or cost for a traffic citation may petition the court at any time to waive payment or fine or costs or any portion thereof. However, the state respectfully submits that the defendant is not entitled to seek relief under either of these subsections. In the defendant's motion, the defendant has failed to make a showing that this court has in fact assessed a reinstatement fee pursuant to KSA 82110 subsection C or any additional charges pursuant to KSA 82110 subsection F in this case. Likewise, the
He's doing this all
state
from
respects
memory,
submits the defendant is now entitled to seek relief under KSA 82110E2. That statute specifically provides that a person who is assessed a fine or court cost for a traffic citation may petition the court that assessed the fine or cost at any time to waive payment of the fine or cost or any portion thereof. The plain language and use of the past tense in this subsection, the state respectfully suggests a procedure for seeking post-conviction relief, and the state is not aware of any journal entries of conviction or sentencing on file with the court in this matter. However, if the court finds that the defendant is entitled to seek relief under either of these sections, the state respectfully submits that the defendant has failed to meet his required burden of proof. Regardless of whether relief is sought under either of these sections, both subsections specifically mandate that the defendant seeking relief must make a showing to the satisfaction of the court that payment of the amount due will impose manifest hardship on the person or the person's immediate family. In paragraph 1 of the defendant's motion, the defendant alleges 9 separate financial obligations in varying amount. However, the defendant has failed to attach to the motion any bills, ledgers, proofs of payment, or other documentation confirming the alleged amounts. Additionally, in paragraph 1 of the defendant's motion, the defendant alleges a new source of income over 2 months before the defendant's motion was filed with the court, but fails to allege any amounts received from such source of income. In paragraph 2 of the motion, the defendant alleges the existence of an attached poverty affidavit, but the defendant notably failed to attach any such poverty affidavit to the motion, nor is the state aware of any separate poverty affidavits on file with the court as of the date that the state filed its response, nor is the defendant's motion notarized. Under these circumstances, the state respectfully submits that first, the motion is not properly before the court. The defendant is not entitled to seek relief under any of these subsections, and if the court finds that both of those are in fact proper, that the defendant has failed to meet his required burden of showing how paying any amounts owed in the current case will impose a manifest hardship on him or his immediate family. And for those reasons, the state does move the court to deny the defendant's motion in its entirety.
Wow.
Mr. Collins, anything else you want to say?
Brock laughs.
According to this hardship piece of paper form that I filled out, everything that this young man is speaking of, it wasn't noted in there. So as far as all these extra attachments and whatnot, first of all, I don't have to lie about my job. I don't have to lie about any of my financial responsibilities. And I'm trying to make an effort to try to get all this stuff done. So in regards to what he's saying, I mean, if the courts grant that, fine, but if not, that's fine too, because I'm just trying to do what I got to do to give everything legal and become I'm a law-abiding citizen. I've made mistakes, I've fixed them, and I'm trying to correct this one as well. So, with the addition to Sedgwick County, the city of Wichita, Derby, I've gotten all that stuff situated, and you are the last person that I'm having an issue with, and I didn't have none of these issues, and I feel that the same type of hardship form to get my fines and my tickets done, and everybody else agreed to it. So I don't understand why this young man is making such a big fuss about presenting this, presenting that, when I just followed the lines of the affidavit.
So you've had convictions in at least 3 other jurisdictions, and you filed the motion to, like you did in this case, to go back and set aside the fees and fines, and they all just kind of rolled over on it, as the saying goes?
Yes, ma'am. I mean, I don't have to lie. You can check it. You can check into it yourself.
Okay. Well, all right.
And then I called the Department of Revenue in Topeka and spoke to her, and I just sent in a $400 payment to pay my fine there and my restitution there with them. So I have made the effort to get all this done. Like I said, it's been over 20 years since I've had a license, and now I'm in a position to get them back. And so now I'm doing everything that needs to be done and get these certain fines taken care of that she told me that I needed to get taken care of in order to make sure that happens. And November the 18th, I will get my license back.
Unless Mr. Aguirre has his way, and then you'll still be filling out papers.
Mr. Aguirre, one thing that I would ask you is your opinion on whether or not the statute he's relying on is retroactive or not.
Your Honor, I am currently in the process of researching that matter, but so I'm not in a position to advise the court fully on that issue at this time. It is the states that are saying that this court has addressed that issue in the past, and I am in the process of researching that issue. As to the only thing I would add further is it would appear that the defendant has admitted on the record today that he has the financial wherewithal to send $400 to a necessary state agency. So again, the state would respectfully submit that further calls into question the appropriateness of the motion, if indeed the court again finds that this motion is before the court, and 2, that the defendant is entitled to seek relief under 1 or 2 of these requested subsections.
Mr. Collins, where have you been? Why have you not paid this before now?
Well, I've been incarcerated. Okay. I've been in the hospital. I almost bled to death. I had a bleeding ulcer. So I've been dealing with a lot of other issues, personal issues, other than the fact, like I said, legal obligations that I've been incarcerated. Having a bad attitude. I mean, like I said, I've grown up a lot. But at one point, I had a disposition that wasn't quite what one would be considered normal. I had a real bad attitude, so it kept me in trouble a lot. So being in and out of the penal institution, that prevented a lot of things from happening. And then along with other stuff. So. But like I said, I'm in a position now, I'm in a better position, a better headspace, and I'm trying to move forward instead of continuing to go backwards. And that's all I'm asking. I'm just asking for assistance to get this done.
Well, Mr. Aguirre, I'm not sure the timing on these things matters, but you did get the motion and you got it in time to prepare a written response. But you're objecting to what part of the procedure?
As a preliminary matter, the state is objecting to the to whether or not this motion is properly before the court in the first place for the reasons stated in the response.
And for the hearing record, that reason is?
She wasn't listening.
Your Honor, pursuant to paragraph 3 of the state's response, KSA 60205A1D provides that, quote, except as otherwise provided in this chapter, each of the following papers must be served on every party a written motion, except one that may be heard ex parte. And although the state acknowledges that the defendant's motion does include boilerplate language for a certificate of service, such boilerplate language includes neither a purported date of service nor any purported recipients of the motion, nor does the motion include any attached documentation in support of any attempts by the defendant at serving the motion in the Butler County Attorney's Office as required by statute.
Oh, man.
But again, I go back to somehow you got the motion. How did you get the motion to prepare a response if it was never served on you? Did you go down and get that because you heard a rumor that it was on there? Or how did you even know it was on file if he didn't notice you for it?
Your Honor, my office received notification that this matter was set for hearing for an unknown reason, and for that purpose, I accessed the electronic file.
All right.
Notice
What I'm
received.
inclined to do is give you more time if you want that, Mr. Regier. Set this over and we'll hear the further arguments and any evidence at a later date. Or do you want me to proceed at this time with what we have?
Your Honor, the state is prepared to proceed in this matter if indeed the court is prepared to proceed in this matter.
Proceed.
Well, I've got a lot of folks, as you know, here, but let's go ahead. Mr. Collins, do you have any evidence you want to present today to support your request?
No, ma'am, other than what I've just told you. I mean, like I said, I've made a lot of mistakes in life, and I'm trying to correct them. Like I said, I've just got out of court with Sedgwick County, the city of Wichita, both Park City and Derby. And like I said, I'm just trying to clean up my record, and I'm trying to get my license back. I have an opportunity to be a CDL driver, and I'm just trying to move forward. So with everything that's going on right now, you know, opportunities, I've had a lot, I've messed up a lot, and I'm just trying to correct them as I go.
Okay, Mr.
And all I do, oh, excuse me, go ahead.
Do you have any evidence, anyone you want to call, any documents you want to show?
Are you talking to me or are you talking to the district?
Talking to you, Mr. Collins. I started to go to Mr. Regier, then I decided I'd go back to you for a few more things.
Well, the only thing that I really have is like, I have a letter from the Department of Revenue letting me know when my license are due to be returned to me once I get all my information done. I just got that letter. Like I said, I don't really have a whole lot to show. I can show check stubs, but I wasn't prepared because I'm not at my house right now. I'm at my friend's house doing this. She helped me with the Zoom situation to make sure that I came to court on time. But I do have check stubs from Johnson Control in Park City, Kansas. I'm just trying to do what I got to do. That's all. I'm not asking for no special favors, but I'm just asking for assistance and trying to get these matters taken care of so I can get my license back.
All right, Mr. Regier, the state's response to this argument?
Again, Your Honor, it would appear that the defendant has admitted on the record that he has no evidence, and by statute, the defendant is required to carry the burden of proof in this matter. Additionally, it is the state's position that pursuant to paragraphs 4 and 5 of the response, the defendant has failed to, or rather paragraphs 5 and 6 of the response, Your Honor, forgive me, that the defendant has failed to present any evidence, both by his own statements on the record and by the face of the motion, that any reinstatement fees have been assessed in this case specifically under KSA 82110 subsection C or F. And the language of the statute would appear to suggest, for purposes of subsection E2, procedure for post-conviction relief, and the state is not aware of any journal entries of conviction and sentencing in this matter. Alternatively, if the court finds that the defendant is entitled to seek relief under either of these subsections, the the state's position is that the defendant has failed to meet his required burden of proof, both under evidentiary grounds and for the reasons stated in the response.
So how is it that this old case does not have a journal entry in it? 2002, and you're saying we don't have a journal entry?
Your Honor, the state is not aware of any journal entries of conviction or sentencing in this case.
Okay, but did he pay his ticket and was found guilty on at least the speeding? The insurance, he should have had to come to court.
One moment, Your Honor.
Okay, I'll look at that too from this end.
The judge sounds like she's trying to find a way to help him out. Every other city and township and county has helped him out. Jay Regier,
I think there may have been a time when the district
buffering does not compute.
Whoever was doing the traffic at the time may have allowed them just to go to the clerk and pay a fine and costs.
Your Honor, if the court is prepared to accept a proffer,
I will accept
from the public portal access case summary, this is a case that appears there have been no payments of any kind ever submitted.
What about that journal entry? No journal entry either?
Not from the state's understanding, Your Honor.
Okay, I'm going to ask the clerk, do you see anywhere in here a journal entry of conviction, or would you expect to if he just paid it at the clerk's office?
Your Honor, it may be down in the folder downstairs. It's an insurance charge, so it depends on how they filed the case back when they were doing the cases this way. If it was not listed as a must appear or a big file, I'm not sure if I would have the case.
And Your Honor, and there does appear to be a notation in the same public portal access criminal with a notation dating December 19th, 2002, that would appear to suggest a failure to appear.
Okay. So you didn't even appear to finish up your case, Mr. Collins, back in the 2002 era.
But he filed a motion to show up here to address it.
That's probably why your financial balance is 586. That's probably what got you suspended, not paying these cases like you were supposed to. If you're coming in here asking me to waive your costs and fines, and you didn't even come to court and finish up your case, so I'm going to deny the request at this time. But we do need to get this case resolved. Are you going to have an attorney represent you on this speeding and no insurance charge, Mr. Collins?
Well, I guess so. I have insurance now, and so I guess not.
The question is whether you had it on 9/22 of 2002. Are you able to hire an attorney?
No.
Are you working at all?
Yes, I am, but I can't afford no attorney.
Where do you work?
At Johnson Control.
Oh, you've told me that. And they pay you how much per month?
I make per month after taxes.
Well, I think it's before taxes, but if you want to give me that, I'll take that.
Well, I average $1,200 every 2 weeks. I just
$2,400 a month. Well, I don't see you qualifying for a court-appointed attorney at that. You might. Are you married or single?
Single.
Do you have any minor children you legally support?
Yes, I do. I have a 15-year-old that I have custody of.
Okay, that will help.
Okay, any other children or dependents?
I do pay child support for my older children. I'm still paying on that, yes.
Okay, how much do you pay per month for that?
$350.
$350?
It's in the paperwork. If you look at the motion and everything, all my financial obligations are listed.
Okay. And what do you pay on your utilities?
I pay $202 a month for electric, $150 for gas, $150 for water, I have a ongoing bankruptcy case that I paid $340 a month for that.
He qualifies.
Transportation for gas and food and everything, that's about $300. Yeah, so everything comes up to be about average a month, $25.62.
All right. Well, even though you're
You
getting
actually
paid
receive
good
more
money,
than what I make.
yeah. All right. I'll go ahead and appoint Attorney Darren Patterson if you want an attorney. If you want one.
You get Darren, Mr. Patterson.
And I'm going to set this over to a Monday at 9 a.m. Missy, or I'm sorry, Destiny, when do you want that?
Your Honor, I have December 15th.
Well, I'll be back here December 15th. I wonder if we ought to put that on a 1:30. Do we have any 1:30s around that time?
That would be a Monday, Your Honor. Would you like to set it for a bench trial on a Wednesday instead?
Well, I'm just thinking. I want to make it convenient to Mr. Patterson on a Monday, but at the same time, this could take a while, so I don't want to take a long docket. And let's try for a Wednesday afternoon at 1:30, non-interpreter docket, not one of those.
Of course, Your Honor. I have November 19th at 1:30.
It's better.
Mr. Regier, will that be sufficient for the state?
No objection, Your Honor. And the state will be requesting really just if that is for control purposes or some other purpose.
Let's make that for...
As the court has deemed it appropriate to appoint the public defender to this matter.
All right, we'll set it for control. And Mr. Collins, you'll need to be back here November 19th at 1:30. But today you need to call your attorney, Darren.
November 19th or December 19th?
Well, which is it, Destiny?
It's November, Your Honor. 11/19/2025 at 1:30.
Trying to get my damn license back. I have my license back on the 18th, and they got to go through all of this mess, man. That's crazy.
All right. Well, you talk to Mr. Patterson. He's very competent in these areas and can give you some good advice and help you present your case well. So his phone number, or do you want his phone number?
Yes.
You ready for it?
Yes.
31.
We're not going to give out Mr. Patterson's phone number. We don't do that. All right, it's time for lunch. We only got half an hour before we come back. So
You're welcome. If there's nothing further, Mr. Collins.
Your Honor, there is one final matter.
What's that?
Yes.
Your Honor, count 2 of this case does appear to be charged as a Class B misdemeanor, and the state is not aware of any appearance bonds in this case either.
Oh, man.
All right, because you have a B misdemeanor, I am required to order that you go into a breakout room. It's going to come up on your screen here in a minute, invitation to breakout room or something like that. Click on that, and you'll go into a breakout room with court security 2. He's going to set up with you a time for you to get out to the Butler County Jail and get your picture and prints taken. I won't make you put up a cash bond, but I will make you put up 1,000 OR. You won't have to put that money up unless you fail to come to court or comply with bond conditions as ordered by the court. But you will need to set up a time to get out there and get that done by your next court date.
Yes, ma'am.
Anything else now, Mr. Regier?
Not from the state, Your Honor.
Anything further, Mr. Collins?
No. This is ridiculous. Trying to do right and get paid.
Well, watch what you're saying, Mr. Collins. You don't want to get into other problems. All right. Please, Destiny or whoever's running the hearing, you could put them in the breakout room. Else we've gotten court security. Mr. Collins just needs to click on that. Did he do it? It looks like maybe.
All right, we're gonna bail.
All right, we are now going to take up Kuhn on the record in BU 2025.
We're not gonna take up Kuhn. We're gonna go to lunch. We need to go to lunch so I can get some food before we come back and go to court as we continue. As we continue through the sentencing phase, the defense is taking over this afternoon. See, I think I got everybody here. Peter Ware, tough day to have a milestone. Yes, we got that one. OG. Tomoto Troy, we got you with an OG as well. Micah, 31 months. Love you, OG. Thank you, Micah. Michelle Marcus, welcome to the gallery. Thank you so much. And SJ giving out 5 memberships there at the end to cap things off. We're going to go to lunch tonight. When you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. We already have a portal set up. We'll be live at 12:55. It even rhymes. So very few minutes. You don't have time to DoorDash. Just grab something out of the fridge, open a Tupperware, throw it in the microwave, pop it down real quick, and be back here. We're going to portal back over for the next little bit. I think it's going to be short. The next little bit of this sentencing phase, which because of defense is taking forever. All right, we'll see you after lunch. Bye-bye.
I'm trying to have court. Don't raise your voice. I saw a chicken fight.
Thank you, sir. You're my new best friend.